Testing. Testing.
You've preserved it.
We need one more person to give the meeting. Are you saying? No, that's true. Are you saying you need to turn this on because it's 10 o'clock?
Yeah.
And then what's reflected is the bars? Or is everyone listening to me? Yes. We just need one more person. And then I can start. That's okay.
Yeah.
A copy is available on the back table should you wish to pick it up regarding that opinion. So that's a total of 3 public comments we received concerning 12.0005. The Rules Revision Commission is meeting on Tuesday, January 23rd to discuss and provide input, as was requested by the board, on the San Francisco District Attorney's request for a new rule of professional conduct. The drafting team in Ujvala did a great job preparing this committee's report and recommendations on today's agenda. We will definitely get to that shortly, but the RRC is also meeting just to consider it and provide any input they may have concerning the rule request. And the board meets on Saturday, January 27th in Los Angeles to receive and discuss this committee's report and recommendation. No decisions have to be made right now at this meeting, but if anyone were interested in representing the committee at that meeting, that might be welcomed, and staff can work with leadership to discuss whether or not that's a possibility, and if so, who might be best suited to do that. And lastly, Monday, February 5th is the deadline for applications for this committee, and I would strongly urge everyone in this room to give thoughtful consideration for quality individuals who you think would be good members of this committee, and if you're aware of them, to strongly encourage them to apply. I say this every year, but you know, the strength and quality of the committee and the committee's work And the reputation of the committee is really derived by you all. And you all work in this area of law, and I'm sure you have colleagues and others whom you know would be great members to serve on this committee. And you guys are the best resource that we have for identifying those individuals. So I strongly encourage you to encourage those of whom you think would be good members. If you need a copy of the application, please ask either me or myself. We can get that to you. You can email it to them. I don't think it's too difficult to fill out. And if you have any questions about that, please let me know. But know that the deadline is coming, and we need great applicants so that we can have great people on the committee. And the more people apply, the better the composition of the committee is. And that is all I have to report.
Andrew, just to refresh people's recollection as far as that process, so the application deadline's early February, and then the interviews would typically be around the beginning of the summer. Is that right?
Yeah, we do need, we'll have to speak, leadership and staff will have to look at that. I don't have, so usually it's a July board meeting in which they approve the applicants. So working back from that, usually, I think we have a June 8th meeting. We should, just off the top of my head, I think June 8th would be the meeting at which this committee would vote to approve the slate of nominees to send to the board for approval. And so, yeah, we're looking probably like a March or first week in June day, once in LA, I'm sorry, May, or the first week in June, once in Los Angeles and once in San Francisco, depending on how many people apply, to hold a day to interview the applicants.
The board decision typically in that July or early to mid-summer time frame.
Yeah, I don't have the board's agenda in front of me, but there typically is a July board meeting, and it's at that meeting which they approve the nominees, so that's how that works. Yeah.
So Andrew, can you tell me again what the date is of the LA meeting where they're going to be discussing or the proposed rule?
Sure, it's a Saturday, January 27th. So typically, this is the board's planning meetings, and usually they don't take action, but they have a lot of items coming up, so they are spending one of the days to take action. And so Thursday and Friday are planning sessions, planning meetings for the board, and on Saturday the 27th is a day in which they'll be taking action. And as it stands right now, they're not set to begin until about 1 o'clock or so. So, if you're interested, please let us know.
Yes. And what's the deadline for the applications for co-practice?
Monday, February 5.
Okay.
All right.
All right.
The next agenda item is approval of the open session action summary for our December 1st meeting. That was included in the materials that everybody received in advance of today's meeting. Hopefully you've had a chance to look at it. Is there any motion to approve the action summary?
I move to approve the action summary.
Is there a second?
All right, here we go. Andrew Dilworth,
Yes.
Amy Bonzi,
Yes.
Kendra Basner,
Yes.
Stephen Bundy, Eric Dykes,
Yes.
Justin Fields,
Yes.
Matthew Hodel, Joel Osman, Marlo Richardson, Dina Roche,
Abstain.
Teresa Schmid,
Yes.
Ujjwala Singh, Richard Solomon,
Abstain.
Stephen Sparta, Marshall Whitney. Thank you.
All right. As far as our substantive agenda, we're going to move around a little bit and not necessarily do things in order today. The first item I want to address is the report and recommendation to the board regarding the proposed rule from the San Francisco District Attorney. Andrew alluded to this earlier. As you all know, we discussed at the last meeting a request by the board that we look at a proposed rule from the DA that essentially would prohibit the disclosure of an individual's immigration status absent that being an element of an offense and/or going through a process with the court, essentially an in-camera process, to receive permission to make that disclosure. So we had a subcommittee, as you know, that was appointed. At the last meeting, we talked about our views and reaction to the proposed rule and sort of a structure for this report and recommendation. And so the subcommittee worked on that report, and I would say special thanks to V.SPECIAL as well as everybody else on the subcommittee, but she did a lot in terms of helping get an initial draft of the report going. And so you have in your materials now what is the result of the subcommittee's preparation of the report and recommendation. I want to go over that. As Andrew indicated, we do have a timing issue. Since this is the last meeting in advance of the board's next meeting, this is the last meeting that we as a committee will have a chance to comment on the draft here and approve it in whatever fashion we want, whether it's as is or with a recognition that there'll be some minor adjustment. But this is our last opportunity to address this before it gets sent on to the board. So just as a quick overview, as you may recall, and again, the report is reflective of the discussion we had at the last meeting and the different types of issues that we had talked about. But our bottom line recommendation is that as to the proposed rule submitted by the district attorney, we are not recommending that proposed rule be adopted at this point in time. And the letter basically lays out 3 or 4 primary reasons for that, which we discussed at our last meeting. But just to remind you, they're essentially the fact that there is pending legislation that essentially is very similar to what would be in this proposed rule. And so that is out there, and it remains to be seen what happens with that legislation. There was also concerns about separations of power and the process that was within the proposed rule sort of dictating to a court or a judge how and what they must do in connection with the admissibility of evidence and related issues that are already covered by not only the court's authority but also various rules and procedures. There was also some constitutional concerns. Among them, First Amendment concerns was one, the notion that this might be a prior restraint on speech, and the last 2 sort of concerns, if you will, were that this is essentially really a partial solution, even if you were to adopt the proposed rule, given that it applies only to attorneys, and the rule would purport to apply not only to criminal proceedings but civil proceedings as well. And of course, individuals tend to represent themselves at times in pro per in a civil action, and so you're getting a partial solution potentially, but not a full solution. And the last issue was a concern, quite frankly, that there might be situations, especially in the criminal context, where from a criminal defense standpoint, there could be a legitimate reason for immigration status to be disclosed, and concern about whether or not the exception within the proposed rules language was really broad enough, and whether it could have a chilling effect on a vigorous criminal defense, and at least without further input from not only the prosecution side of things, but also the defense side. We didn't feel like we were in a position to say that would be a good rule to adopt. So we laid out those reasons. As you know, we did come up with a variety of alternatives that we thought could be ways to address what everybody recognizes is a very serious problem and issue. And those, in a nutshell, were either to adopt a comment perhaps similar to what the Washington State has done with their 4.4a, and to put that comment with proposed rule 8.4, which is pending now in front of the Supreme Court, A second option would be to consider adopting 4.4A, which hasn't been done and was not something that was part of the recommendation by the Rules Revision Commission, but we don't think that that's necessarily because the commission didn't think that that would be a good idea. We think that rule just, for whatever reason, didn't get a lot of attention. So one option would be to look at adopting 4.4A and putting a comment there. And the third option was essentially to do a comprehensive ethics opinion. And so without getting into all the details of each of those arguments, although we certainly can do that, the structure of the letter is a summary up front, and then we basically go through the reasons in more detail that we're not inclined to adopt the proposed rule as it was submitted, as drafted. And then we go through the alternatives in terms of 8.4, 4.4, an ethics opinion. We do not take a definitive position on what the board should do in terms of those alternatives. And we discussed this before, but I think the committee is open to any of those options, and also, some direction from the board in terms of what they might, be more inclined to do. As far, there's pluses and minuses to each of those options, and of course, timing is an issue too, because under any of them, if it's a comment to 8.4, that has to be approved. If it's getting 4.4 into consideration for adoption and a comment to that rule, that's not even in front of the Supreme Court yet. And an ethics opinion, of course, takes some time as well. But I think, and I think the subcommittee also thought, that it makes sense, instead of saying definitively this is what you should do out of these three alternatives, to tell them what they are and see if they have some direction in terms of how they feel. And that way, we could, assuming they want further assistance from us, we can put our efforts into a task that is commensurate with what they want to do. And the letter is qualified enough. Quite frankly, we don't know what they'll say. They can come back and say we want the proposed rule, and we don't put that out of the equation either. But the letter, I think, tells them what our reaction is to the proposed rule, lays out various options, and lets them know that we're here and willing and anxious to work on any of those, but certainly they could give us some direction in that regard. One question, I guess, and I'll just raise this, is we don't take an affirmative position, and so in that respect, is there anybody who thinks we should be more definitive in terms of saying, assuming you're not going to adopt the proposed rule and you're going to look at one of these alternatives, this is the alternative that we most recommend, or something to that effect? My personal view is I don't think that's necessary. I'm more inclined to get the feedback from them and let them tell us what that is. And I also think any of these three would be acceptable. Conceptually, in terms of this issue and how it's been framed in submission to the board, I think that the notion of having it under 8.4 as a comment, with the idea that this is something that's prejudicial to the administration of justice, I think that fits. And I guess, maybe if I had to be polled right now, I might say that's the one I'm most inclined to lean to, the three options. But I think it makes sense under 4.4A as well. And I'm not inclined to stake out a position on any of those three. I'm more inclined to say, let the board tell us what they think. But that's just my view. Does anybody have a strong feeling to the contrary? Think we should be more definitive on our alternatives? They could get this to say, oh, well, okay, we understand you're not recommending the proposed rule, and there's these other options. What do you recommend? But I think if that were to come up, it could be said that, well, let me ask this quickly. Do people tend to favor one of the comment approaches over the ethics opinion?
I favor that. Do I have to press something? I hate this. I don't know, what do I press?
It says
The
push.
push.
At the bottom.
Pushing is
At the
nothing.
bottom.
You go once the light's on. Yep,
Oh, there you go. Well, I prefer a comment because it seems to me, that's the cleanest way to do it and the fastest way to do it. And I agree with you that it really is an administration of justice issue. It interferes rather with the kind of, it adds a stink to it when a lawyer takes advantage of, unfairly, without proper cause, takes advantage of someone's immigration status. So I think that's the cleanest way and the fastest way. And I would think they would want to know our opinion if we agree, if there's a consensus for it. So I would personally like to be a little bit more definitive in that sense if there's a consensus for it. I don't think it undermines whatever else is in the opinion. I think the letter is wonderful. It does capture, I wasn't at the meeting, but it does capture the soup of the discussion. So I think that could be just added with a little bit of wordsmithing.
Okay. To your point, just to be clear for everybody, one of the things we discussed, I mean, the intent and the motivation is key. I mean, and we're not reiterating the language here of the Washington comment, but it's focused on that. I mean, it's the motivation of making the disclosure is what is largely dispositive. Any other views as far as a comment versus it? Is there anybody who strongly favors having an ethics opinion as opposed to having a comment on one of the rules?
As a practical matter, the time to publication for an ethics opinion seems to be strongly against that.
Well, I agree, and I agree with that, and I also just tend to agree that it would be better to have it in the comment. I don't see any reason not to. I think it fits, like I said, conceptually, if we get 8.4 and or if we wanted 4.4. One.
Drew, I agree with you. I think, but as between 4.4 and a comment, I'm agnostic. Like, I think either one would be a good solution. But I actually think it's important. It's a good point that, especially because ethics opinions have now been relegated to, I don't even know what status under the new rules. They certainly would be less binding and would not be binding at all, in fact. So I do think having it in a rule or a comment is better, and we might want to say that, but as between whether it's 4.4 or a comment to 8.4, I think either would be good, personally.
I have a suggestion, or this is an option. Instead of recasting the letter to be more definitive, it seems to me that our representatives at the board meeting could be prepared to say, based on this discussion, if there was a desire to know where is the committee leaning in their recommendation as to the three alternatives. I think it could fairly be said, and the person could be prepared to say, the committee favors having a comment, and the issue is whether you put that under 8.4, which is pending approval, or whether we take up the task of looking at 4.4A. And the committee is receptive to either one. 4.4A may have a timing issue, obviously, that's different than 8.4, depending on how quickly 8.4 is considered and so forth. But that's an option too. I mean, I don't know what their reaction is. I don't know. I personally don't feel strongly that we need to change the letter and pick, but I think whoever's there, if that, I could see that being a possible question that comes up, and I think the person who's there should be able to answer for us as a committee, and I think they could, as say on behalf of the committee, we're inclined to a comment. And really, the issue of whether it goes 8.4 or 4.4, in large part would depend what the board wants to do, timing, how I mean, there's a sense here, I think, from the materials that have been submitted to us already that they're concerned about the timeliness of the issue. So, despite my having no qualms about 4.4A, I just think from a pure timing standpoint, they might prefer to have it under 8.4, assuming that we hear pretty promptly from the Supreme Court.
So it is one easy form, why not?
Yeah, so we'll do a quick straw poll. How many people are in favor of arming our representative with the authority to let the board know that we're leaning towards a comment, but we don't have a strong position as to which rule? How many people want to do that as opposed to taking a more affirmative position in the letter?
Can I ask a question?
Sure.
Comment what does that, how, does that include 4.4, adding a new 4.4B? When you say a comment?
Yeah, if it goes, if it's if the comment goes in 4.4, then that has married with it the task of basically proposing 4.4A, right?
Yeah.
Yeah, that's what I'm saying. So really, I don't know how much help we're giving them. Well, put it this way, getting a new rule adopted will mean we have to wait pretty much, we have to go through that process, which is a pretty long process.
Right.
I'm just not sure.
Well, that's the timing issue, right?
Yeah.
I mean, it would make sense if they wanted to adopt.
So what we'd be really saying is we favor something that's not an opinion. We'd rather go with either a change to the rules or a change to the comments, and we don't have a view as to which is better as between those.
Yeah, I think that's
Okay,
That's
if
right.
that's with that as a friendly amendment.
Yes.
Yeah. Okay.
Sure. And so, how many people favor that message from our representative to the board at the meeting versus, changing the letter to sort of affirmatively stake out, we think the better position is to put it under, 8.4 versus looking at adopting 4.4 and having it down. Steve, you just looked like I messed up your friendly amendment.
You did change the question.
Yeah, you
I
did
will
change
say
the
you did
question.
change the question.
All right.
But I think the idea isn't the overall idea.
Well,
it's-
I actually think now that it's clear, I think the question is, should we say that in the letter, or should we say it by adding a sentence or two to the letter, or should we leave it to the representatives?
That's the question.
This is,
Ultimately, isn't the question, does the majority of the committee,
So there's
support that view?
Oh, okay.
First, what's our
Right,
view?
because we
Second,
kind of
should
jumped
we
there.
let our view?
Right, I think.
All right, so the first question is, we're going to take a poll to see how many people support having a comment to either 8.4 if it's adopted, or to 4.4A with the contemporaneous, adoption of 4.4A, over having just an ethics opinion.
Or no representation.
no,
Oh, sorry.
Finally got the full question, so let everyone just weigh in on that.
If
It's
I-
just a straw poll
Right,
question.
it's
yeah,
just a
I think
straw poll.
we're all on the same page. I think
Yeah.
the question is,
I
in
did
order
too.
to
That's
address this issue, does the committee recommend an ethics opinion or a comment?
You have to make it a yes or no question. So, does everybody agree that the committee recommends a comment over an ethics opinion?
There you go.
That's fine.
Straw poll. Everybody agree that we would recommend a comment over an ethics opinion?
All right.
That's the, and that's it.
Okay.
Next question is,
So-
how do we deliver the message?
Yeah.
How do we deliver the message? That's the next question.
Well, and, I don't know that you have to affirmly, you certainly can. You can and discuss this and stake out position. You don't have to. When staff presented this to the board originally, we made clear that the board would be, after the report and recommendation came back, the board would have all their options available to them. And that included many of what's listed here. And so what this exercise has done has made it helpful should the board say to the representatives, well, thank you, we appreciate these options. What is the opinion of the committee between the three? And now we're informed as to what that is, and we could respond orally. And so I don't know, and I think that's, in my view, that's sufficient. However, if the majority of the committee wishes to stake out an opinion between the three, you could consider that. I don't know that that's necessary. I'm not sure I would really recommend that, because of each of the three involves a different set of analyses and opens up another, not can of worms, but I mean, you'd have to thoughtfully explain the pros and cons of those. And so I think you've done your task in this report. This exercise was really to inform whoever represents the committee, should the board press that individual, thank you, of the three, what was the view of the committee? That person, I think, is now informed.
Right.
So I think,
Comment over opinion.
exactly. And then it really is a board decision to determine what rule and how to do that.
Okay. So we have that out of the way. Any substantive comments on the draft report and recommendation itself?
Okay, so I actually, and I did participate in the writing of this letter, so I apologize for this, but I wanted to point out one thing to just make sure that, I just noticed it in this 2A, where we say this is a complex and politically charged issue that we believe would be better addressed by the legislature. But then we later make recommendations on how to address the issue. So I think what we're really saying is the proposal raises a complex and politically charged construct. Like, this rule is what we think should be considered by the legislature, not the entire issue. It just seemed a little, like, you read this first thing and it just sounds like we're punting on the whole issue and saying it's better off left at legislature. We're saying whether or not this rule should be adopted is better off left at legislature, because they have a version of this rule pending before them. So that's one thing that just jumped out at me. If you just read that first thing, it sounds like we're punting, but we're really not. We have some other
Right.
suggestions. So I would just suggest maybe wordsmithing that a little bit, changing the word issue maybe to proposal or something, but I don't know. If you
Well, I mean, I think that's a fair point, actually, but I like the way you said it, which is the proposed rule. Because again, I mean, we're starting out by saying, the bottom line is we don't recommend the proposed rule, but then we come up with alternatives. But the proposed rule is a complex and politically charged issue. I don't know if we even need to say we believe it's better. I mean, it's an issue that is being addressed by the legislature. I mean, because the bill that is pending is essentially if not identical, virtually identical to the language that's in the proposed rule. And I think that that's our point. And as you read through the letter, part of the argument is, you might have inconsistency. Who knows what's going to happen? You should wait and see. If you're going to think about this rule and this language, you should wait and see what happens with this bill.
Yes, that's a good point. So maybe the first rule.
It's a complex and politically charged
That is
issue that is being addressed by the legislature.
or that, well, at least it's pending. We don't know if they're going to address it or not.
So, well, a couple things. It's not right to say a rule is a
Involves.
charge issue. Yeah, there you go.
Involves.
And then,
Do we even need this? I mean, when I heard Drew just speaking, I was thinking maybe, isn't our just a point that this is in front of the legislature? Whether or not it's complex and politically charged.
Yeah,
Should we maybe just make an amendment to say that our first, the first point is the same issues in front of the legislature.
Right.
I think that's a word clarification.
in that format, that exact format, it's pretty much before the. So we would, and should be left to it.
Should we say the substance of the proposed rule, or the
Yes.
import or purpose of the proposed rule is currently being addressed by the legislature?
Well, but then later we do address other ways to address the import of the rule. So, I mean, the fact of the matter is that very rule is under consideration by the legislature, and we don't think we should step in.
So we want to take out everything else, right, the particular, right? Yeah, we take that out.
Should we say something?
I think it's kind of implicit, but
Well, and remember, this is the summer. They discuss it in more detail later on in the letter.
Oh, right.
Is it addressed or considered by?
considered.
Yeah. Yeah, we do say it again, but. I mean, Suzanne, if you're turning to where in the discussion, we pull this up again, we could say the proposed rule addresses a complex and politically charged issue. That satisfy your concern?
Except for that we say that we believe is better addressed by the legislature than the rule of professional conduct.
Well, we do believe that, right? This particular.
Right, that particular articulation.
Well, that's why we say the
Right.
proposed rule addresses.
Right.
So,
Yeah.
so I think that fixes the issue.
But I think your clarification was a good one in the summary and recommendation.
Now that sentence has the word address twice.
Proposed rule addresses. Well, we can say
Involves.
involves. The first one, change rate. Concerns.
Complex and politically charged issues.
No, I think it's one issue. No, it's good the way it is.
Right, because it does have to do with the introduction of evidence.
All right.
I guess I have one question. I was on the committee too, so I feel bad about raising this now, but at the very end, we say, we pretty much leave everything, say like, don't tell them which way to go. But in the end, we do say, we would wait for SB 785. And I just want to make sure, do we really feel that way? I mean, I don't know how long something can, the legislature's as slow as co-practicing.
Well, you're looking at the very last page.
It's a good point.
Yeah,
I haven't read the Senate bill, but does it really take care of the problem much better than the proposed rule?
well, I don't even think that's
It's almost exactly the same.
Says a party instead of a lawyer.
But it still applies only to lawyers.
Well, and about the introduction of evidence in court.
But offered by lawyers, so it doesn't address the pro per problem.
No, it says a party shall not instead of a lawyer.
So it's a bit broken.
But I don't, I mean, just to be technical about it, we don't say we should wait just for the bill. We say we should wait to see what the legislature does with the bill and what the Supreme Court does with the new rules, particularly 8.4D, which I think.
oh, but whether,
So what
whether
we're-
it gets adopted.
Yeah, so I mean, I don't think we're staking out that the bill is the ultimate. I think this leaves the ability that if 8.4 gets adopted, then, you know,
That still doesn't make sense though, because we're not saying, let's wait to see if the Supreme Court adopts 8.4 before we then think you should go back and recommend a new comment.
That is what we're saying.
Right, and I don't think that's what we mean. I mean, part of what I think we talked about last time was that if it's a comment to 8.4, the idea would be while it's under consideration by the Supreme Court, stick in this other issue, hey, you know, whether or not the Supreme Court has already decided 8.4 or not, we would want to add this to the considerations that the Supreme Court.
potentially in advance of them making the determination on 8.4.
And I just wonder if we really need this paragraph.
I was just kind of wondering.
I mean, I actually am not of the view that a comment to 8.4, we need to wait for the legislature to do anything. And I think if say the legislature does something, you know, changes the evidence code in some way, I don't think that's gonna, there still might be an ethics issue that we wanna say, it's also ethically improper to do this. So, I guess yeah.
Yeah, I agree with that.
So with that
Take up.
proposal being to take out the essentially the last portion, the second to last paragraph.
The whole last, the second to last paragraph, yes. I mean, I also don't know why we say things require additional study.
Seems- Yeah, I think I agree with that. I don't have a problem taking out that entire paragraph.
Anyone object?
No objection? Anybody else have comments on the substance of the letter? All right, is there a motion to approve submission?
Really quickly before whoever makes a motion, if I could request a friendly amendment to permit staff to make non-substantive edits, but in particular, the reference to the exhibits, which I understand why you would want them in this letter. The reason why I'm raising it is I've already drafted a general board item which has several attachments. Both of the exhibits are referenced here, and so it's more cohesive and makes more sense if staff were each permitted to delete the reference to the exhibits. Don't worry, the two exhibits that are specifically referenced are definitely included in attachments, and they will be provided to the board. And then, of course, if there are any spacing or just topographical, grammatical issues, we're all on the same page.
Can't allow that.
If staff's permitted.
Absolutely not.
Okay.
That's fine.
Okay, thank you.
No
Well, really, the substance would be the reference to the exhibits. We're going to take those out, yet include them just in a different fashion.
Understood. Okay, any motion to approve the letter as it's been edited today for submission to the board?
So moved.
Second.
All right. Andrew Dilworth,
Yes.
Amy Bomsey,
Yes.
Kendra Basner,
Yes.
Stephen Bundy,
Yes.
Eric Dietz,
Yes.
Justin Fields,
Yes.
Matthew Hodel, Joel Osmond, Marlo Richardson, Gina Roche,
Yes.
Teresa Smith,
Yes.
Ushvala Singh, Richard Solomon,
Yes.
Stephen Sparta, Marshall Whitney. Thank you.
All right, the next agenda item, just very briefly on 12-0003, which is the Attorney Directory and Rating Website opinion. As you know, public comments closed on that opinion. We've had some discussion in past meetings about those comments, and Joel is taking the lead on coming up with some potential minor edits based on those comments. He's not here today, but I anticipate that at our next meeting we'll be able to discuss that in more detail and bring some closure, I think, to that opinion. So the next item is 12-0005, which is the disclosing mistake opinion. And that has been out for public comment, as Andrew indicated. Public comment is now closed. We have essentially 3 items in our materials in terms of public comment. One is a letter from BASF, their ethics committee. The other is from the LA Bars Ethics Committee. And as Andrew mentioned, we also have an Orange County Ethics Committee letter that came in just yesterday. If you don't have that for some reason, there's copies in the back of the room. But let's go ahead and address the public comment on 12-0005. And Amy, you're the lead on this. Do you want to sort of start us off here?
Sure. Okay, so the letters are all from ethics committees, and so they're thoughtful and not goofy. But they're different. BASF's letter is very brief, and it doesn't it suggests a lot of sort of broad, like reconsider and refine. But I have to say, I don't think there's too much we can do with it, because I think we've thought very carefully about all these issues, and I'm not sure what the refinements they have in mind, and they haven't articulated any precise issues. So I'm not inclined to make my view is would be that there aren't any specific comments to address here. One exception, possibly, on their fourth comment is that we should engage in greater discussion and application of the California rules and ABA rules. And I don't really, that surprised me because I think there's quite a hefty discussion of both, or at least inadequate. But what I thought possibly they meant is in hypothetical 3, which is obviously the most controversial one. We don't actually go back and talk about the rules there. I mean, essentially because Hypo 3 ends up saying it's just like Hypo 2, and in Hypo 2 we do talk about the rules. So I thought we might want to, the committee might want to look at whether there's any, we would want to actually rediscuss or at least reference the key conflict rule in the context of Hypo 3. Now, LACPA likes our conclusions. I mean, I got the sense that at least some people on Bassett aren't sure about all our conclusions, but there obviously must not have been consensus there. So LACPA likes our conclusions and makes a lot of very specific, some are pure like editing, like use a plural and then singular. So on those, I mean, they have found some typos, and I think we should address those. I generally, where they had substantive comments, overall, I tended to think that it's really the sort of comments that someone in the room might have made. It's possible that someone could have a different view, but ultimately, none of them caused me to have a concern about our existing opinion. I want to hear what other people think, but other than the very specific kind of typo-y grammar suggestions, I wouldn't really be inclined to make any changes based on my comments.
But my take on LACPA was that, I mean, most of them are typo. I mean, there's really only a handful that are substantive.
Right.
So what it seems like what you're really saying is you're inclined to adopt some of the various typographical stuff, but on the few that are sort of more substantive, they're not swaying you.
Correct. That. And then Orange County, this is, of course, my reactions. Got it more recently. So, but their first thing is that they want us to change the hypothetical facts because they think that a statute of limitations issue is more complex. I have a very negative reaction to that because I frankly think, I think it doesn't matter. I mean, I frankly think we could just say, like, assume the lawyer thinks he might have made a mistake of some sort, right? I mean, we've given some facts just to make it fun, but so I wouldn't be inclined to change the step. And I don't really understand what they're saying.
Well, just to be clear, aren't they? I mean, we have the statute of limitations. That they're saying they don't like the statute of limitations,
exactly.
right?
Because it's complex or because it's not complex enough?
Well, I think they're saying that we're wrong, that it might be the case that, if you miss a statute of limitations, you might still be able to file a cross-claim complaint.
I can speak a little bit to what that, I think the issue was, at some point in the opinion, we say something like, the lawyer missing the statute of limitations therefore means that malpractice has been committed, or so, that there's at least the risk of malpractice, and the reaction was, well, not always. That Adams versus Paul in particular says that, I guess, missing a statute of limitations doesn't necessarily mean you committed malpractice because the defense has to be raised and all that. So I think, honestly, whatever the comment is could be, I don't think it really requires a change of the facts, but there is this point where I think we say something making it sound more definitive, that missing a statute of limitations gives rise or could give rise to a claim or something. But I think it could probably be addressed.
Well, I guess we can look at that language. If we say it gives rise, that's one thing.
I doubt we said it that definitively.
Me too.
There was something.
But it could. I mean,
it could.
I mean, and to some extent, isn't that kind of,
I couldn't tell if they were saying, we want you to have an example where
a definite mistake or something like that, that's gonna be incurable, which is kind of, I mean, to some extent, the opinion is talking about the fact, and it's beneficial to have a situation where it's unclear. And we discuss how, you know, maybe the lawyer in getting advice will get advice about the issue. Maybe it's not as bad as he or she thought. Maybe it can be corrected. Maybe there are things to be done. And that's part of the reason we don't have, you know, adversity yet. So, I mean, it doesn't bother me, but if we stated the law incorrectly somehow by being too affirmative, then I think we should modify the language. But other than that,
I'll look at that and then see if I can find whatever that phrase was, but I agree with you, really. It's beneficial that it's not clear. If it was so clear, then there's not very much to talk about.
Right.
But if you want to stick with Orange County just for a second, you want to go back?
Let me just finish
Sure,
my
sure,
overview.
sure.
And then I feel, I guess my reaction, the bullet point, the second thing is that they want us to clarify under what circumstances the proposed opinion would suggest an actual conflict is evident and what to do. So I think we should talk about this because I'm surprised. I feel like we do say when an actual conflict arises, and we say what to do. I mean, we say what the initial things we have to do are. So anyway, I was a little surprised at that. So maybe we should talk about it and hear other people's thoughts on what they meant by that, or why they're raising that. And then the last two, they say they want us to talk about what the outside counsel or in-house counsel could discuss with the lawyer and could not, like what things would cross the line into adversity and not. And I am afraid that will get us deeply bogged down. And I think it's sufficient the way that we just noted that there's limits.
that's ground we've covered before too, in the process of getting to the public.
Yeah, I think that we already crossed that bridge, right?
Yeah.
Oh, didn't cross it, however you want to describe it.
And then
We battled on it on our second.
yes, and then they want us to give specific examples of when the fact of the consultation with in-house counsel would be a material development. And I don't know. I mean, I actually find that hard to do. So, and I don't think it's necessary. I mean, I just don't think, I think that this opinion gives good, helpful guidance as is, and there are more questions that will always come up, but it doesn't have to address and provide the entire Bible of how to deal with them.
This clears a lot of weeds.
Yeah.
Right?
It's not a treatise.
I totally agree, but on that last point, I just have to say, off the record, even though we're on the record, I have always read that sentence and wondered what that scenario would be. And other committee members, former committee members, have articulated it at times, and I've heard it, and I still don't get it. But that said, I don't think we need to go. I mean, I get the concept, but it does always make me wonder, sort of, well, what is that scenario? But I don't think we need to. I don't think we need to go there. So we don't. And it has been articulated, and I know that there's principled rationale behind that language. We didn't just come to that language.
Okay, so maybe now that I've kind of described generally,
Sure.
what else is on that?
All right, well, so I guess we can, we can start with scope subcommittee. Going back to the San Francisco opinion, I mean, I agree, it's not very, it's not very detailed. Number 2, which talks about a fuller analysis of imputation. I mean, I'm not sure what that means. It may mean that they don't agree with the imputation analysis, which doesn't, persuade me to, we spent a lot of time on imputation and talked about the issues, and we have the conclusion we have, which some people may not agree with, but basically that, because the seeking of legal advice in itself doesn't create a conflict, we didn't think there was imputation to discuss at that point in time. And this seems like, I'm just reading that there's a negative pregnant, that maybe, they don't agree with that conclusion. That's just a guess, but I don't have a particular view that we should go back and revisit that. Number 3, I didn't really understand, quite frankly. I tried to follow the page and the sentences, and it didn't make sense to me. Someone understood it. I mean, page 9, the 2 sentences in the last paragraph.
Sure, what?
Oh, I agree, and it actually made me think we need to start numbering the drafts that we send out, numbering the page lines. It gets very difficult to follow people's, specific comments, like penultimate paragraph on page 9, the following 2 sentences in the last paragraph, and then it also seems in parentheses that they have an issue with the first sentence. So I agree. I was like, what is your issue? However,
It's imputation, I mean,
it's about disclosure, but there was a fair point, I thought, in there. If you look at page 9, the last paragraph, based on our analysis, there's no reason to treat differently a consultation by a lawyer with firm in-house counsel under the facts described. But they seem to have lost the fact that it says under the facts described, but that seems to be one of them. It's not always the case that it's the same. So that was one thing. And then the last 2 sentences, further, as noted in case law and commentary, there are potential benefits to the client and the law firm of having in-house counsel involved, including accessibility and timing. And I think and I'm just guessing, but it seems like that is pretty definitive. There are potential benefits, and maybe they're saying there may be. There's not always potential benefits.
This is not even, I don't even think this is the paragraph they're talking about.
I think
This is ultimate. The penultimate is.
something, I think they mean the last one.
Oh, you're right, you're totally right. And you're
Yeah.
also right that we need to number the lines.
Right, because it's hard to follow.
Yeah. So you
But
think-
anyway, that's what I thought. I thought they thought we were being too definitive about, there are, and I know probably the source of that comment, but, there are benefits to in-house counsel,
It says
Right, and it says potential, I agree, but I'm just saying, that's what I think, that's my best guess,
Okay.
having not been in the room and really having no idea,
Okay.
So it sounds like you weren't inclined to do
I'm not,
anything.
yeah, I didn't understand it, but understanding it that way,
I think it says potential.
potential means that it may and may not. And I think that's true. There are potential benefits to having a discussion with in-house counsel.
Number 4, which is the one you had highlighted, Amy, on the business of discussing the application of California's rules. It may be what you said. The only other thing that struck me is, and again, it doesn't say it, so I don't know, but if they're suggesting here that, well, where's 3.310C? And my answer to that would be, we can put, it gets back to the imputation. We don't deal with 3-310C because our conclusion is that the mere seeking of legal advice in and of itself is not creating a conflict. And so I don't know if that's what they're saying. That's the only other thing I could think of. But if that is what they're saying, again, I think that's something that just is saying we sort of disagree with this imputation notion, and isn't there 2 clients now in the 3-310C type scenario, which I would not be inclined to go back and change, quite frankly. The other reference to the ABA model rules, I was a little perplexed by that because I think the very beginning of the opinion talks about the ABA opinion and cites 1.7, and so I'm not sure what they really want in terms of additional model rule discussion, or what would really be that relevant. The opinion's relevant. The ABA opinion is predicated on 1.7, involves 1.7. When we cite that opinion, we cite 1.7. I don't think we have to say everything that the ABA opinion says about 1.7.
So that was just kind of my reaction to that one. If it is just, well, you mentioned 3-310B early in the opinion, and it's not, maybe it'd be nice to hear it in the third hypothetical. I mean, I suppose we could do that, but that doesn't seem necessary to me. If that's what it is, that doesn't bother me. If it's 3-310C, that's a more substantive issue, but as I said, personally, I wouldn't be inclined to go down that road. And then I guess on the LA, I don't know that we need to go through every single one. I mean, all of the things that were sort of technical comments, I largely, didn't have any problem with them. I mean, they're right on some of them. Some of them I thought, well, it's not necessary, but we can make that change. It's not substantively altering anything. But I tend to agree that on the ones that were more, the few that seemed to be more substantive, I wasn't inclined to make modifications based on that. That's just my 2 cents. We already kind of covered Orange County as far as my thoughts on those bullets. That's just my perspective. So why don't you, Suzanne?
Sure, yeah. So I think with respect to San Francisco, I really wish that they had given us more. There are some really, smart people on that committee and really probably had something to say, and I would have really liked a little bit more fleshing out of what the, and I see Kendra smiling, so I'm
just
guessing, yeah.
Just to note that I did not participate in this, and nor did I attend the meeting in which this letter was developed. I thought it best if I
You're off the hook.
Yeah.
So,
Darn, 'cause
unfortunately, I
was hoping you
can't answer your questions.
We might have benefited more by
Right.
having you participate there.
I was at a hearing that day, sorry.
Yeah, because you can see there's probably a fulsome discussion that was the underpinning for these sort of conclusory suggestions, and it's making it difficult to try to really address them.
What I do know is when this issue first came up, Richard Citron was attending and giving his perspective on this opinion, which we all informed on. And I know that it was a pretty heated debate and it was pretty split. So I think what they ultimately ended up doing is, instead of being more specific, because not everyone agreed with that specificity, they decided to be more general. But I too agree that this is not as helpful as it could be if it had a little more detail for us to go off of.
Right.
It also doesn't surprise me to hear that this is a list that's the product of disparate viewpoints.
Yes.
I kind of read that into it
Right.
as well.
Right.
So whatever they meant and whatever the fulsome discussion was, doesn't necessarily strike me that there would have been a strong consensus as to the additional detail. Maybe that's why they didn't
Right.
provide it consciously. I don't know.
Right, and I was not at that meeting where this letter was developed, so.
So I will say though, with respect to even the sort of conclusory statements, it does sound like they are touching upon issues that the Orange County letter was raising, at 5 and 6, where, reconsider and refine the question of when the threshold of the duty to disclose and conflict of interest issues are reached. Consider whether the opinion should address what actions the lawyer should take after the threshold is reached. And so I think I see them sort of pointing to the same thing that I think the Orange County Bar Association is pointing to, but I do agree with Amy's and Drew's. It's hard to go there. And we talked about going there, and we decided, it's really hard to go there, and we can't, so we're going to stop at the point of conflict. And so while I agree it would be great if we could give more guidance to lawyers that are really in this situation, because it is artificial to assume that you're going to stop your conversation after you find out you made a mistake. The natural next question is, how do we protect the firm, And so there's this feeling when you read it that you're just not getting full guidance. And I get it, but I think there's a reason why, because it's hard to
I
to
do
make that.
recall when this was first being discussed, that it was that point of timing that was the biggest concern, is the explanation of when that is cut off. And so I think that you're right. I think it's more focused on that. When is that line drawn? And should it be drawn there or not?
Right, and should we say something, like, should we give more guidance about when you reach that point? And I don't know, maybe we can take another look at the opinion and see if there's a place where you could say, for example, if you're asking for, but I thought we did, if you're asking what protective measures can be taken to protect the law firm, that's off limits. I thought we said that in here, but.
Yeah, I mean, I don't, I mean, with respect to their bullet point 5, which says reconsider when the threshold duty to disclose and conflict of interest are reached, I think we absolutely reach a conclusion on that. And to the extent they don't agree with it, they need to tell us why it's wrong, and they haven't, I don't think. And I don't think there's any refinement, because I think it's quite express. I mean, 6, what should happen next? We don't go there.
But that, quite frankly, was a conscious decision, as Suzanne's alluded to. We talked about that, we looked at that. That has problems, especially in sort of a hypothetical ethics opinion scenario. And so, I mean, I get that too. I mean, this isn't the end of the story. But I also agree with Steve that this clears a lot of weeds. So, but I'm not inclined to, personally would not be inclined to shoulder the task of let's tackle what happens now that you have a conflict and what you can say or do in that context with inside or outside counsel. And I think we've decided as a committee not to do that. I haven't heard anything to change my mind as to why we should go back to revisit that, if that's
I agree, but
I think that's what they're.
Right, because as soon as you go there, then you've got to get into imputation as well, which is also part of the frustration you can see being expressed by San Francisco. And I get it, but imputation is a mess to try to get consensus on. So I think
what we're doing with this opinion is we're really making clear, right, that there is a broad area where there isn't any conflict, right? And that's an important thing to do. And then we're not going on to define in detail exactly when the conflict arises and whether it would be waivable and all those different kinds of things. That feels like it'd be a whole separate opinion.
So that was my thought on the San Francisco one. Do you want to go one letter at a time, or because I did have some thoughts on the LA. I actually thought LA had some good points, but
yeah, sure. I mean, anybody have any other thoughts on the San Francisco opinion, or not opinion, but the letter, San Francisco letter? I think we've sort of covered it pretty well.
San Francisco forfeited its right to be considered by not telling us guidance.
Not telling us what they're really thinking.
If they had a suggestion, they should have made it.
All right.
And Orange County, I agree with the Orange County. I think I'm with Suzanne. I think LA is the letter, right, that we need to think about. I actually thought it was really substantive and smart. I don't know whether these points are important, but they all seem to me to have some real grounding in either logic or the substantive law.
I think some of the issues that the San Francisco Ethics Committee were referencing are covered in some of those letters, so moving on to those.
So with respect to LA, I thought that the first point was a little bit of wordsmithing, but not necessarily. It did seem to make it a little clearer in terms of us shifting back and forth between lawyer versus law firm, and to make it clear that it would apply to a solo as much as to somebody practicing in a firm. But I didn't think that we should take out the word outside counsel. because their proposed language was that you say what ethical obligations arise when a lawyer consults another lawyer concerning matters related to the firm's representation. And so they're trying to encompass the lawyer down the hall. And that lawyer down the hall is going to have the same obligations as the in-house counsel or not. So it just seemed like a mess to do it that way, that it should be outside counsel, even if we consider incorporating the other suggested changes, which I'm sort of agnostic about. That's what I thought about one. Number two, I thought, that was a wordsmith that I thought was fine. I thought 3 was fine. I thought 4 was a substantive decision that meant some discussion among us, because first, it's kind of a funny point, but if it's true, we should address it. That if we say that 3-500 and 6068M codify, or I should say 6068M codifies the Neal opinion, and it predates it by a century, we probably shouldn't say that.
We don't say that. Look at what we say. It's ridiculous. We say.
Let me see. I thought that when we looked at it.
Where we are.
Yeah, let me see where we
You
are.
don't say that those statutes codify too.
Let me see.
Third paragraph of this section.
This, I wish we had the.
I know.
Here it is. Yes, it's
Right.
right under duty to communicate with clients.
Yeah, we don't say, we say that we use the language of Neal rather than using our own words, which lawyers commonly do, to describe the duty. And then we say that duty is codified. I just don't think that we say that those statutes codify it.
They're saying, yeah, but that's a subtle distinction, because we're saying, what we say is this duty is codified in California Rule of Professional Conduct 3-500 and 6068M, and they're saying that the duty articulated in Neal is different than the duty articulated in 3-500 and 6068M. So that's the most substantive thing. And then the second thing is that to use the word codify when the statute predates it by a century is, I understand you want to say, no, we're just talking about the duty, not the case.
Right.
But that's a pretty fine line when the duty is different as articulated. So to me, I don't think it's a difficult fix. I just don't know that we need to use the word codify. But couldn't we just say this duty is,
Reflected.
reflected or something? I mean, it's.
I have language to suggest. This duty was first codified in B&P Code 606-8M, but later included in 3-500.
But that doesn't get to the comment that the duty is slightly different.
I don't know. Do you think they are?
Well, I don't know that we want to get involved in that, but I mean, I certainly would say that they appear to be different. That the Neal articulation does seem a little bit broader, and that's talking about potential civil liability for breach of fiduciary duty, which is not what the disciplinary rules are about. So I do think the disciplinary rule is a little bit more narrow, intentionally so, probably, because it's a disciplinary rule. So, but I don't know that we need to figure out if one's broader or the other. Certainly the words are different that are used. So.
Would their comment be addressed? I recognize their comments hyper-technical, but I think Suzanne's comments making me slightly reserved, so I'm not sure this is going to address it, but the duty addressed in Neal is codified in,
No, that would be worse.
because they're talking about the duty to communicate. And Neal is simply a description.
But they're saying Neal is broader than the statutory articulation.
I think if we said.
Or you could flip-flop the citations. You could just bring the rule and the statute first, and then cite what's described in Neal second.
So
That's, it is true. Neal is talking about the duty of a fiduciary. So Neal is talking about the scope of the fiduciary duty, and that is different than the disciplinary rule. but maybe it's something like, you know, this duty is reflected in, or this duty
Why don't we just say
is
that
encompassed
the duty of
within?
communication is set forth in California Rules of Professional Conduct 3-5.
So we're making sure that we just, if we have the words, the duty to communicate, right? Then we sort of
Yes,
signal a little bit of a break from the rule.
yes,
Restating it.
yes.
That
Like
enough?
or
And do you want something other than codified?
this duty to communicate, why don't we just say is stated?
Yeah, that's nice.
Okay.
I hated this comment. I said, too picky.
You didn't like that one. I think that, I thought that comment 5C was interesting. I don't know why. Oh, right, there seemed to be taking issue with our citation to the restatement third of lawyer, of whatever, of something to do with lawyers.
On page 3.
Right, and saying that, that restatement third of the law governing lawyers is just not the law in California. That seems to be how I'm distilling what they're saying. And that, because number one, it says it doesn't have to be substantial malpractice claim in order to trigger a duty in California. And also, in California, the lawyer doesn't have to disclose the malpractice, that there's a claim for malpractice, but just the facts underlying it. So that seems to be the gist of what they're saying, and I thought, well, I don't know, but what does that cite do for us that we don't already have in the Palmer case and elsewhere? You know what I mean? Do we
Well,
really need
it
it?
supports the fact that the other authorities generally support the view. So I would definitely not live or die on keeping it at all. But I also don't think I don't think we've stated anything inaccurately. I think we've provided a service, which is identifying that generally the concept that the lawyer has a duty to communicate facts giving rise to real malpractice is not just a California concept. So,
And I mean, I see their point. I'm not sure the average person would read that. I mean, I don't know that someone that read this see also string cite is going to take that language and say, aha, the opinion is saying that it's only substantial malpractice claims. I mean, I understand their point and they're correct, but I just think it may be an example of someone who's very knowledgeable about these issues reading in a way that is, as a practical matter, not going to be interpreted or applied by someone who's.
It seems to me that
Less.
in context, the paragraph doesn't say what they say it says.
Right.
It's true that language from Talon is, that's a New York case. We then go on to explain that you can't characterize the facts as malpractice or not malpractice, and it just feels silly.
Well, and you're still, I mean, the restatement, I think, personally, in my view, is it's valuable to cite the restatement when it's applicable. I think it's a good resource for lawyers. This cite or quote from Talon, I mean, it's in the comment. I mean, if you look at how I'd hate to get rid of the restatement in general and the fact that it's another prominent authority that supports this general proposition, because someone might take a quote from a comment of the restatement, which can have, cites or quotes from cases all over the country, to be, oh, this is a statement on California law to the level of, detail that it has to be a substantial malpractice.
So I agree with that, but what if we assume that you've got a lot of pretty smart people on the LA committee, and they read it and thought, wait, this is going too far. So is there a way that we can maybe change the sentence before, just to make it clear, like general view or general proposition or something that you have to, assume that if these guys read it and thought we were going too far, that the average person who's less knowledgeable might. But I agree with you. I don't think it's something we should take out altogether. I think it's valuable to show other resources, but maybe we do something to the
There's a
sentence
weirdness
that
here.
precedes it.
right? Because I don't think order of hadn't is accurate, right? You don't have to disclose every act of malpractice. You don't. I think you have to disclose those that are material. There are times when you do something that's unreasonable, and it turns out to have no consequences. Do you have to disclose that to the client? I think we don't.
Then it's not malpractice, right?
What? Well,
Well, unless somebody's injured
It's a
by
breach
a
of the-
mistake, it's technically not malpractice.
okay. Well, then, but doesn't that then suggest that the cite to Talon is right? It's got to be. It's got to have some substance to it. It can't just be a mistake.
I don't know. I mean, I think the use of the word malpractice means you have all four elements of a tort. And so, and I think what they're saying is, you don't weigh, like, how much malpractice was it? If it was a lot of malpractice, then I have to disclose it. I think an argument could be made that if it's malpractice, you have to disclose it. But I don't think we need to figure that out, for purposes of this opinion.
I'm just not sure that I'm not sure there's anything, I'm trying to figure out how to articulate this. California has one standard, which is, I'll accept your view, Suzanne, that if it's malpractice, you have to disclose it, but that also that it's the facts, you don't disclose the legal conclusion, right? These other authorities may have there may be different nuances, but that doesn't mean they don't support that principle. They say other things as well. So I guess I'm not averse to adding a word there. On the other hand, I just think they're wrong. I mean, I think that this is accurately stated, and it doesn't say what they think it's saying.
And it's the restatement, which is not binding anyway. So how could someone read the restatement as the restatement citation to an out-of-state decision in New Jersey is somehow our opinion saying this is the law in California? I mean, let's not lose sight. I mean, the very first sentence is the important sentence. And this string cite is just saying California is not alone in this view that the duty of communication includes disclosing facts giving rise to a legal malpractice claim. And I don't know,
But if we just soften that language a little bit, other authorities, are consistent with, or something like that, or generally support, or something that's a little bit.
How about generally support?
Generally support.
But this quote from the restatement doesn't support that, and it's incoherent. So I'm all in favor of quoting or referring to the restatement when it's helpful, but this is positively not helpful, because it says, first, this is a substantial malpractice claim. We don't have that rule. And then it says, must disclose that. Well, what is that? That you have a claim or the facts underlying the claim. So the statement itself is, frankly, very confusing. It doesn't help the analysis. I think we just take out that cite and we cite Talon, and then pick up with New Jersey Supreme Courts. We have all authorities which support the California view. We're not alone. We make a point. We remove something which is truly confusing, as they picked up. And if they picked it up, other lawyers will pick it up. And then why are they citing it? I just don't think it really is inconsistent with the rest of their, because it's wrong. It doesn't summarize California law.
But we don't say it summarizes California law.
But it implies, we say, here's the authorities which support where we're coming from, but this quote doesn't.
Just to be clear, Richard, are you suggesting taking out the restatement cite, or just
Right.
ending it at comment C 2000 and not quoting Talon?
The quote, if the lawyer's conduct of the matter gives the client, that, assuming, I haven't checked, but assuming that's a proper quote of the rule of the restatement, that does not reflect California law.
But would you still cite restatement, just say section 20 comment C?
Why? If that's what it says, you're directing someone to something that is quite irrelevant to our situation.
Suspect there may be more to comment C
Yeah.
than that
Oh,
single
well,
quote.
sure, if there's more to it that's more appropriate, then I would have no problem with that. That particular phrase, to me, is inconsistent with California law, so therefore the question is, well, why do we cite? We're not writing a treatise on the various approaches to this dilemma. We're saying this is what the California approach is. So why would we cite something which is contrary?
Well, I think if we say generally support, to me, that could take care of the issue. Another easy fix potentially is if we looked at comment C, if it's talking about this more generally, and we can cite that, and this quote is just something that got plucked out of a fuller discourse, we could leave out the quote, and we've provided them with relevant authority to look at that generally supports it without creating any confusion by quoting some particular language. I just don't know the answer to that second fix because we have to look at the restatement. But personally, and again, I have to look at this restatement section again, but I would not be inclined to take out the restatement. I think that's typically very helpful authority. So if this particular quote's a little bit confusing, we can leave it out, fine. If we need to say generally support to make it clear that we're not saying that these parenthetical quotes are somehow stating exactly what California law is, yes, Steve?
Why don't we just say generally support and take the quote out, right? It's very clean. We have the restatement in there, and we're not making a claim that it's identical to California law, right? And that way we can move on to.
Yeah.
Well, is there consensus that what the lawyer must disclose in that quote, the term that refers to the lawyer's conduct, or that there's a substantial malpractice claim?
Well, we don't know, but the proposal is to take out that quote
Yeah.
and simply cite the restatement section and add the word generally. So it's other authorities generally support this view, cite the restatement, take out the quote, and then move on with the rest of the.
The very next sentence says you're not allowed to characterize it.
Right.
Explicitly. So if we take, there seems to me there's not really much risk of misunderstanding.
I think it covers it. I still think this is somewhat overtaking.
It's a little bit of overkill, but it's clean.
But yeah, okay.
So Mimi, the other authorities support this view is already there, so you would just put the word generally.
Oh, fine.
Yeah, that was it from my perspective. That the other things I agree with Amy's view on the other points made. Some of them are worked.
Not to belabor
That's
this.
right, that's how my snarky comments were circular.
Yes, I agree with you.
Not to belabor this, but I'm just looking at the comment C to the restatement section, and it's a litany of different scenarios regarding a general duty to communicate, and in parentheses refers to a failure to disclose malpractice. That's the extent. And then
What does that mean?
Parentheses.
that we include, that if we delete it, it's contextually we can still reference the restatement without necessarily including reference to Callan. That's
You're saying there's no problem with this at all?
Good. All right, anybody else have any comments or any of the other points from LA that we haven't covered that they have?
Well, I have a comment on that same paragraph. I think the citations that are in there show that we support that they have to notify them of the facts and not the legal conclusion, but if you look at the actual sentences that we are saying, we do not spell that out. And I just thought if we wanted to be more clear, if you look at the sentence after I guess it's the New Jersey Supreme Court Advisory Committee, it starts, and an attorney is not required to specifically disclose. My thought is you'd say required to specifically disclose to the client the legal conclusion that the client may have a malpractice claim. And then the last sentence, there are more citations after that, and then the last sentence says, however, under Rule 3.310, the attorney may have a duty to advise the client of the conflict and the facts giving rise to that conflict, that he or she, and go on from there, so that we actually say it instead of just relying on the citations. We can use other language if you don't like mine, but.
Right. I remember when we discussed this previously, one of the issues was that the Thielen case does suggest that you have to, it's not as clear as these other authorities that say you just have to disclose the facts. Thielen is a little more ambiguous about whether you have to disclose that it's at least potentially malpractice. And so I think that's why we ended up not staking out too firm a position on whether it's just the facts or the malpractice. That's my recollection of the genesis for avoiding that. And it is kind of a disputed issue for some. So I think that's why we kind of cited authorities but don't stake out a specific position about how far you have to go with what you have to disclose. But that was before. It could be different.
Well, you're talking about just sort of adding on, right?
Right.
Yeah. It doesn't sound like you have a real strong substantive problem with the way it is. You're just saying
Right.
you could
I
go a little
think that
further.
the point is being made in that paragraph,
Right.
but that it's being made through those citations and the quotes that we include from some of those citations, but that we don't actually say it. Now, obviously, I wasn't involved in any conversations
Right.
on this opinion before where that might have been a conscious decision, but I think it says it regardless, based on what we quoted, so.
Okay. Well, I mean, I do remember those discussions to some extent, and I think that being more overt about it could take us down a path a little bit in a way that may not be so productive. And given that it's there, and I think in a reasonable fashion that people are going to pick up on, I guess my inclination would be to leave it. Anybody else have a strong feeling one way or another about that? For changing it?
Well, I think the first suggestion that Kendra made, I think helps clarify in that sentence. I don't think it says anything different than what we've said, but it clarifies the legal conclusion component. I think it adds, I don't think it's different than what we're saying in the sentence.
So an attorney is not required to specifically disclose the legal conclusion. What was your language again? The legal.
That's it, yeah. Specifically disclose to the client the legal conclusion that the client may have a malpractice claim.
Well, then I don't
I
think-
want to just find the Thielen case to make sure we're not.
Maybe we should be even clearer, right?
What's that, Steve?
At the risk of doing a little bit of.
An attorney is not allowed, right? Right, it's not allowed to, right? Isn't it stronger really than
Right,
not
because the
required?
second half of that sentence says that doing so would be providing legal advice.
Right. So that's where the rubber hits the road on this. One is, are you giving an opinion as to whether or not there's a malpractice claim, right? And that you can't do, because that's clearly an issue of conflict. Whether you have to say the words, hey, you may have a malpractice claim, I don't know, one way or the other. Some would argue, yes,
Yeah.
you do have to say that,
I've
because
seen-
otherwise
I've certainly
the
seen a
client-
lot of letters that do say
Right.
that, or say a reasonable person might conclude that.
Right, so, because some believe that the client is not a lawyer often, and so the client is not in a position to know what the consequences or even the potential consequences are of whatever these facts are that you're disclosing to them. So some think, yes, those are actually the words you need to say. You may have a malpractice claim. I don't know. Maybe you do, maybe you don't.
Or you may have claims, perhaps, instead of, because as you were saying before, Suzanne, with what a malpractice, proving malpractice and all the elements that go into it, and what actual legal malpractice is, as opposed to, there could be other legal claims that may be brought against the attorney based on
How about
their actions in the contract.
How about this as an amendment? How about the attorney, right, is not permitted, oh, darn it, the words went out of my mouth, out of my head in the moment that but let me see if I can grab them back from wherever they went.
Okay.
The idea would be is not permitted to take a position, right, or to state a view on whether or not, something like that. Is not permitted to take a position on whether or not, right?
Client has a claim.
Yeah. So I'd leave out may have a claim.
Like, I almost would feel more comfortable if we just took out malpractice and said may have a claim against the attorney.
But I think you can say, I think we want to say, you can say that you may have a claim against it.
Right, but to
Right.
me, the word malpractice is a very specific thing.
It definitely is. I mean, and some people would say that unless you go that next step and say you may have a claim, I don't know if you do. You haven't given a full disclosure to your client. So I don't want to foreclose that as a possibility. We don't need to take a position on it, but I certainly wouldn't want to foreclose
Well, we could
for
say
people
this.
reading it. Oh, I don't have to say that.
Maybe this is too much.
Right.
We could have a first sentence that says, right, the attorney may suggest the possibility, right, that the facts give rise, right, to a malpractice claim, but may not take a position on whether they do so.
You
Something
could
like
address
that.
that comment in the last sentence,
Pardon?
Your comment could be addressed in the last sentence of that paragraph with the, under rules 3.310, the attorney may, although that's specific to 3.310, but may have a duty to advise the client of a conflict
The facts, the advice, the topic,
and may
yeah.
have a potential claim or claim against the attorney.
That is a little different though, because
But that's not
yeah.
interpreting 3.310. I know, I see the problem. Yeah.
But it really, because Suzanne, your comment really hits me, which is that I don't think we want to necessarily say that we certainly want them to be clear that you can say you may have a claim against me, although I can't advise you about it.
Right.
Or what those claims, which could be multiple, may be.
Right. Yeah, it could be breach of fiduciary duty, it
Right.
could be,
Could be a number of things. But
yeah, so that makes sense to me anyway. So Steve, you're proposing that as a substitution for
I can't, my
The
eyes are so
sentence.
bad, I can't even read what's up there right now.
Just do everything. Sentence that starts in attorney is not required.
I mean, if you really want to get hyper technical about it, if you're only saying to them, you may have a malpractice claim against me, that might not be adequate at all, might not cover everything, and therefore you're really treading on whether you're giving advice on that issue.
Right.
The
Right,
point
'cause you may have
is,
other
you may have a claim and you should see someone else to
Right.
determine what that may be.
So
Right.
it's safer to,
Right.
Well, how about this, the attorney may suggest the possibility that the facts give rise to a claim, you could just say, right? But may not take a position on whether, what? So, on the validity or something like that, on whether such a claim exists.
It may not take a position on, you know,
Whether such a.
whether it does.
Whether a claim exists. May suggest the possibility facts give rise to a claim, but may not take a position on whether a claim actually exists. Or you don't need actually.
And then it says to do so would,
Then you could say, then pick up with to do so.
right, to do so would.
Right. Need to provide legal advice.
I think it should be the facts giving rise to it. Oh, never mind.
Against the attorney.
When we write suggest the possibility, isn't that just being applicable? Can we just say you may suggest the facts may give rise to a claim, but may not?
Or taking legal position on whether it exists.
What the facts may give.
Yeah, that's what I said.
Yeah, may give rise.
Well, I don't know, but there might be in-between scenarios where it's not entirely clear, and you still might be erring on the side of making that
Possibility in
disclosure.
A, or possible.
No, but you're suggesting the facts may give rise to a claim.
Oh, I
You're not
didn't
saying
mean
there is,
possibility.
there is the possibility is encompassed by that, but it's not as, the language isn't quite as.
I think it should say legal possession. Take a legal position.
Well, does that suggest they can take some other kind of position, just not a legal position?
Well, I think it goes into the next part about legal advice.
But if a lawyer takes a position,
Whatever position would the
Yeah,
lawyer
so
take.
it's
I would think
fine.
we should just
So
drop
it's
legal in
redundant
both
then.
places.
right, it sort of
Take a
suggests there might be
position
some
and then
other-
say give advice.
Right,
Yeah.
I don't even know what take, is
Right.
taking a position the right?
But maybe
Express
not-
a view.
Or
right,
opine.
express a view
Render an
or
opinion.
opine would make
Opine.
sense. Or may not opine as to whether,
Pine is too strong.
okay, may not express it.
That feels way too formal to me.
I mean,
Give an
frankly,
opinion.
I think the verb is advise, right?
Yeah.
That's what we're talking about here is,
Okay.
it's not, I mean, that's why I didn't like take a position, because, you know, that's like sort of your.
Yeah, and that's
You don't want the
consistent.
attorney to do is
May not advise whether a claim exists.
advise.
It's consistent with the balance of the sentence.
Yeah, yeah. So maybe not the word on this or as to.
So are we keeping possibility or not?
I don't think we need to,
Don't
because
need
it's
it.
covered by may.
You can get rid of may suggest facts.
Sorry, I'm late to this conversation. I'm curious, where is this sentence being derived from?
What do you mean?
The attorney may suggest facts.
We're changing our formal. This is the formal one.
Right.
An attorney is
I
not
see
required
that.
to specifically disclose.
Right. And what's wrong with that?
Uh,
Where's the requirement that the attorney is?
We actually weren't sure that that was correct. Suzanne's
The
comment
concern-
suggested we thought sometimes you might be required to
Right.
suggest that the facts may give rise to a claim against you, particularly if you have an unsophisticated client.
Concern is that it was going too far. To
Okay.
suggest that you couldn't say, you may have a claim. Or the thing you can't do is you can't say, yeah, you have a claim, or you don't have a claim. But
Oh, I see. So may have a malpractice claim is the problem. Or is part of the problem.
Right.
Could we add, may suggest to the client?
Yes.
That,
It should be vetted.
sentence,
Yeah.
just, you know.
Yeah.
I think it's sufficient without the client again, but could,
You can take out the third may, but you can say cannot.
no, because it is may.
Cannot advise as to whether.
Cannot is, I mean, technically, can is, it's just not right. I mean, can is like physically, like, can't, you have a
Whether it's
physical-
permissible
Oh, I see,
versus
I
whether
see.
it's physically
Yeah, yeah,
possible.
Right.
Shall not.
No, may,
I'll give that to you.
okay, two mays. I mean, you can have, it is permitted, or,
We think it's not permitted.
yeah, that's fine.
Yeah.
Otherwise, 3 mays makes it sound like a very wishy-washy
Yeah,
sentence.
yeah.
It's not permitted.
Not
It's
permitted.
Sorry.
Okay.
On whether.
You can take out
a
the
claim
as to
exists.
whether, to advise whether.
That works. And that takes care of your concern, right, Suzanne?
Yeah, and I think Kendra's as well,
That's nice.
that is more clear.
Yes.
Is that right, Kendra? Does that take care of your issue to some extent, or not really? You're frowning over there.
Only, sorry. So I'll pose this as a question, because maybe, we can concentrate on the same sentence, or maybe I'm not seeing it the same way, but it says the attorney may suggest to the client. So, that may, that first may, is this an option? Because I think we all agree the attorney has to tell the client that there's an issue, we have a conflict. So I think when we say may, it makes it seem like you have the choice. What we're trying to emphasize in this sentence is that, yes, you have to tell the client that an issue exists and that it may give rise to a claim, but you can't talk about what claims they may be or whether an actual claim legally exists, because then you're treading into legal advice. But you have to, I think the first may is kind of reads as.
But it's that it would give rise to, that it may give rise to the malpractice claim.
Right.
So the may is not discretionary as to the facts and the circumstances.
Maybe this is the attorney is always permitted to suggest to the clients, right? Is always permitted to suggest to the client that the facts may give rise to a claim, comma, and sometimes may be required to do so. Right?
Yeah. I like that second part, because I think that's
That's
where
part of what we're missing here,
Suzanne
right?
was
It's
saying.
the idea that in fact there are some clients who are entitled to hear that.
Right, so let's-
Well, that still leaves it qualified,
Right.
which is different than what I think you were saying, although I kind of lean on the side that it should be qualified. I mean, I like what Steve said, which is there may be circumstances where you have to do that, but I'm not sure that you have to do that in every single circumstance.
Well, I think, now that I'm reading the first sentence of that paragraph again, which I can't see on that screen, but. Yeah, the duty of communication requires an attorney to disclose the facts giving rise. So we're saying it there,
Right?
that they have that duty. And then once you get past all the citations.
And in this new sentence is different. It's
Right,
not the
right,
facts.
right,
It's saying that the facts may give rise
Right,
to
so-
a claim.
right.
And we're leaving that as discretionary, saying we're saying you can always do it, and sometimes you might have to do it.
But I think our position is that they have to give the client the facts.
Right.
Right, that's the
Right.
first.
We said that.
Right.
So,
That's,
to Andrew's point though, wouldn't it be an important clarification to make this a separate paragraph, since it is a distinct thought, separate from that which leads the previous, or leads the current paragraph?
Well, I think we need to at least note that really there are three, amazing, in this huge paragraph, there are 3 sentences by us.
the first is at the top, then there's the one we're working on, and then at the bottom, there's however, under Rule 3310. And so let's just make sure that if those three sentences all conclude a one concept, we might want to keep it together.
Yeah, I think just Mimi's comment that there are a lot of mays throws it off. So we should.
Well, didn't Steve made a suggestion of changing that, is always permitted.
To suggest to the client. That's going to give rise to a claim, comma, and it, comma. And in some circumstances, may be required to do so.
I don't want to say parentheses, for example, with a less sophisticated client.
We have a site for that, would be great, right?
I don't think there's any law. I've never seen any law like this. It's a new law.
Tread carefully.
But it makes a lot of sense. Look, I mean, if you could recite the facts to an unsophisticated client and
Right.
they don't have any
You
idea,
could cite the duty to community.
right,
Yes.
that they need to protect their interests.
But we've lost.
We've lost the
Yeah,
legal.
that
conclusion.
last clause
We use that.
disappeared.
Right, no, then you have to add the other piece again. But the attorney,
So undo your last change then, if you don't mind. There. No, is that right?
Yeah, that's right.
Yes,
So, no,
that's fine.
don't do
Leave
that. And then, so that after the period is but, the attorney is not.
and I wouldn't put a comma in there.
Because there's, or just
If you have a semicolon.
I think it's fine. Nice to have- No.
No.
so after the red.
After exists.
Comma, no but. No comma after the but there.
Semicolon.
You got the
No,
sentence.
she.
Oh,
that's-
sorry.
Oh, okay, sorry.
That's my fault, I didn't know what you meant. Contradictory to say may give rise to a claim. But not state whether a claim exists.
That's an important distinction.
Lawyers do it all the time. I've seen a number of letters in this kind of situation where you say, given this, and there's a lot of ways to write it, but some might be inclined to say that, right? And you frame it in a way that law firm phrases it very carefully in a way that indicates they're not endorsing that view, but that it's a view that should be considered. And then they say, and we can't advise you. Right? And if you want to find out about that, you have to talk to someone else. I mean, that's a standard form for these letters.
I feel like we really need to tend to the last sentence of the paragraph, because I think it may not work anymore.
Seems redundant.
It really shouldn't be a however, should it, in some ways?
Right, that's
It
one
should
thing.
be sort of in addition. Or not in addition.
What did you say, under for yes there.
Yeah, I like that. And I'm not sure what the may is.
Exactly. It should be has, right? That works well because now we've set up the conflict point. Right? And if it comes down, we've already said there is a conflict.
Right, right.
For the council recognition of our clients under advising them to change that point. Under the last sentence, next to last line, last complete line, to the right, advising the client, right?
About the existence of that. Because we're just saying previous sentence that you may have to say, you may have to change. She should not advise or complain about the existence of that. Or
But she is,
that too
right?
much? Oh, right, that is exactly what you're saying.
Yeah, it's not advising on the merits? Right, I mean, I think the reason that we say it this way is because we're putting a lot of weight on advising, like advising always means advising whether, but if we said advising the clients on merits, sorry, that would be clear.
On merits of any. So instead of about.
Yeah.
Okay, so under 3 through 10, the attorney has a duty to advise the client of the conflict and disclose the fact that he or she is not advising the client
On the merits.
on the merits
Of any potential.
of any potential claims against the attorney or law firm.
Can we take he or she out and just say the attorney again? In the last list. Just need a gender neutral pronoun.
Maybe I was wrong about that.
Yeah, me too. Let's go back to he or she again, sorry.
Killing me, Amy.
I know.
Sorry. I think that works. All right, does that work?
Here's my final thought, and then. So we say in the first sentence, the duty of communication requires the attorney to disclose the facts giving rise to any, it says legal malpractice. I don't like the malpractice there. I would just say any legal claim against the attorney, but I have not thoroughly gone through that particular opinion. So we're saying there that you have to communicate the facts. You have to disclose the facts. And then we put in this new sentence that says the attorney is always permitted to suggest that the facts may give rise to a claim, which I think comes off as permissive rather than a requirement, which we said in the first sentence. So what I think is we have the first sentence, and then we just go in, but the attorney is not permitted to advise. I don't even think we need that one before the but. Because we're already saying they have to disclose the facts.
Right,
Yeah,
and
but-
what we're saying, in some circumstances, you may have to disclose that it may give rise to a claim. So I think it's an important point that we can't just skip over.
The first sentence and the second sentence are, main sentences are substantively different. The first one is saying the facts.
Right.
The second sentence is saying that the facts may give rise to a claim. It's not saying you don't have to disclose the facts. The first point is you gotta disclose the facts. There's no question about that. The next question is, do you have to say that the facts may give rise to a claim? And the way it's been cast is to say the lawyer could always do that permissively if he or she wants to, and there may be circumstances where the lawyer has to.
Okay, but they don't always have to say
Right.
that this may give rise to a claim.
Right.
Disclosing the facts
You
are
say it
enough.
to the general counsel of a big firm, you may not have to say that.
So,
Say it
so
to
our
any-
position is disclosing the facts are enough unless under some circumstances you may actually have to disclose the facts and then also say that there may be a claim. Is that what we're saying?
Right, we're saying always disclose the facts.
Right.
It's always permissible
Right.
for the lawyer, it's not a conflict, it's always permissible for the lawyer to say the facts may give rise to a claim. There may actually be circumstances where the lawyer has to say that. And then finally, the third point, what you cannot do is you cannot tell them whether or not
Right.
there is in fact a claim.
Okay.
And then the last point really is, and you should tell them, where our last sentence is.
Oh, it's at the downstream.
Yeah, it should, right, but the last point is, and you need to advise them that there's the existence of the conflict, and let them affirmatively know what you can't do, which is I can't tell you whether there's, an actual claim. So I think it's consistent, and I don't think the second sentence, it's substantially different than just the facts.
Right. I guess my reading of the law is that you not only have to tell them the facts, but that you have to tell them that there may be a claim. And just not get into the legal conclusion of that.
I think some people debate, that's a
Okay.
little bit
Okay.
debatable, I think.
You think there
Depends
is,
on the
do
client.
you have some authority for the proposition that you have to say there may be a claim? I think it's really interesting if you do. I'm just interested.
Well, I don't think you have to tell them that there may be a legal malpractice claim or get specific. In fact, I think it's wrong to get specific, but that you have to tell them there may be a claim.
A sophisticated client.
But I think you should do it in
I
every
just,
circumstance.
I just think that's, to me, that's subject to some debate.
Right, probably is.
But what, to your point, what about the first sentence? In this middle section, we have said claim and not necessarily legal malpractice claim. So in the first sentence, should we say the duty of communication requires the attorney to disclose the facts giving rise to any claim against the attorney?
Right, that's,
Less.
Why do we want to
specific.
jump ahead?
Should we say legal claim at least? Because claim it could be
well,
ambiguous.
What-
legal claim may be fine, but that opinion,
But
I think,
I'm sorry, that's
specifically
what-
deals with a malpractice claim.
Did I say take out legal? I would leave legal.
Right, take out
I
just
mean,
malpractice.
do we want to say give rise to any legal claim
Right.
instead of just saying specific?
Why would we want to jump, that may be, do we think that's, it's certainly not what the authorities say.
Well, that
I'm not
opinion
sure,
is
'cause they're-
more specific to a particular scenario.
Right. To the malpractice.
So I'm not
claim
sure,
itself.
right.
I do think most of the authorities come up in the context of malpractice claims. Like, I'm not really aware of one outside, doesn't mean it's not possible, or that the duty wouldn't be the same.
But also, this
Well-
opinion is talking about malpractice.
Well, and the other thing is, I don't know, if you really want to get down to it, if you do something and there's some claim that, I don't know what it would be, I guess, other than malpractice, or breach
Well, that's the
fiduciary
thing.
duty or something, but
That's,
what else would it be? And if there is something else that's weird, would you have an obligation? You have to know what it is, and the whole opinion is about the lawyer's conduct
and the claims would be malpractice or malpractice related, so. I guess I'm just trying to understand, what don't you like about malpractice being in there? That it's under-inclusive, that it could be like a breach of fiduciary
Exactly.
duty claim and not
Right.
just a professional negligence claim?
Right. I mean, you're right, we get into the technical part of it. You could put, you know, under some circumstances, fiduciary breach, contract claims, all of that falls under legal malpractice for statute of limitations, for instance, and other things like that. But there are other claims against lawyers. I mean, fraud. I mean, there could be other legal claims that they could have against a lawyer that might not necessarily fall into the nice neat box of legal malpractice.
But this doesn't say the lawyer only has a duty to disclose facts giving rise to legal malpractice. It says that if you've got a legal, you do have to disclose those facts. It doesn't say that's the only duty.
So if you think there might be another claim
This is-
outside
well,
of that,
this is
you
a-
don't have to tell them.
This is an opinion.
Right.
This is laying out the legal foundation for the analysis of a scenario where the client has a potential legal malpractice claim. So I think, we have to keep that in mind. So this is the legal foundation for, this isn't a standalone discussion of the duty to duty. I think it's a discussion of the duty discussion, but then will support our analysis.
I don't disagree that it could be, the duty could be broader, but that's not necessary to deal with the issues in the opinion. It's not supported by the Arter and Haddon case, right? And I have a concern outside of that, which is I'm not sure it's correct outside the malpractice case. At least, I don't know.
Well, I think the reason, I'm looking at what our issue is, how we framed our issue, and it says an error.
That says what?
This is an error, a possible error by the law firm. So, that seems to be.
Well, an error by itself is typically a malpractice claim, right? An error, you wouldn't call it breach of fiduciary duty, an error.
Well, I think there could be
There can be, it can be
different types of errors.
Right, like
I mean,
an error in reading a conflict check report or something, and, taking on.
And it might not rise to the level of, I mean, we are getting very technical, obviously, but when I read the issue, it didn't seem to be limited to malpractice. But if it is, then there's not that problem.
Well, I mean, in the context of the facts here, I think it makes sense that it's malpractice. I have to say, I share a little bit of Steve's hesitation in the sense that if you start expanding beyond that, you're getting into territory where I'm not sure if the answer is you have to or you don't have to, but it's different territory. Does a lawyer have to say that they've done something that could give rise to a fraud claim?
Well, I think at this point in
something like
time,
that.
what we're saying is, you're not even getting to that analytical stage where you're deciding what the
Well,
claim
that's
is or
right. I
isn't,
mean, you're
right?
disclosing
So-
the facts and the
And-
circumstances of the error, whatever
Right.
it is.
There's a legal claim. I
You
mean,
can say,
very well could be malpractice and falls under that umbrella of malpractice. But at that point, you're not deciding what the claims are, because that could be legal advice. Whatever attorney this client ultimately consults with to determine what claims rise against you will decide where it falls.
Do you disagree with the accuracy of the statement?
I think she's saying it's under-inclusive.
Well, I understand, but it's not inaccurate, right?
No.
And we are talking about a lawyer who may have missed a statute of limitations,
Right.
which is potential malpractice.
Right.
So I don't know that we're I don't know, do you think that we're misinforming people if we state it this way?
Well, maybe what, if we're just basing it on these facts alone, I guess I don't see the harm in just saying legal claim as opposed to malpractice claim. But you all think that's opening it up to a bigger issue. I think it's consistent with our statement that you're not getting legal advice.
I think the issue is that the authorities that we cite are only in the context of a malpractice claim. So the concern is that there aren't authorities that say, for example, a lawyer has a duty to disclose the acts constituting fraud, which
Or
they're not
breach
going
of
to do,
contract.
obviously, because
Right, which could fall under malpractice.
Could.
right, and no one's saying that that wouldn't be the right conclusion. I think that's the concern, is that the cases don't say just claim.
I guess just my reading, malpractice is a legal conclusion. And we're saying you cannot give legal advice.
Right, but for the attorney to even have the duty triggered, the attorney, who is an attorney, knows that that is at least potentially a malpractice, right? Because if at some level, somebody doesn't think that it's potential malpractice, then you have no duty to disclose in the first place. So I think that's why the authorities say what they say, that it's acts of malpractice, because triggering the duty, you have to at least know that. Now, it doesn't mean that you can tell the client that this is what I think the claim is, but on an internal, in your own brain level, yeah, I think they have concluded that there's a malpractice, or at least a potential malpractice claim against. Otherwise, there's no duty to, someone has concluded it, whether it's that attorney or outside counsel.
I'm just not sure. I would advise my clients to say to their client that here are the facts, and you may have a potential malpractice claim against me. I would say you may have a potential legal claim against me.
Right, which is
Well, yeah,
what
which
that
we say
second
below.
sentence goes
That's
to.
what we say in the second.
But what you're saying is the first sentence shouldn't
Well,
say that the
I guess
duty-
I was thinking of consistency, but, and my comment when I said that was that this State Bar formal opinion, which is the first cite that we have after that sentence, is specifically talking about malpractice. So if that's what we're using for that statement, then
Right, the Order and Haddon case.
And that's all we have, basically.
Yeah.
All we
And I think that makes sense. I also think as a practical matter, you may actually be reading that phrase, any legal malpractice claim, in a way that, the average lawyer is gonna read these facts and think about it the way sort of Suzanne read it. You're reading it from a very, maybe sort of more technical or informed view of someone who's gonna defend certain claims and stuff like that. And if it's accurate, it's supported by the authority doesn't go beyond that, I think we capture your concern in the next section where you say, I would say, it may give rise to a claim, which would be broader than just saying malpractice claim, that's fine. It seems to me like that is sufficient. I do have concern about, if you take away malpractice in that first sentence, you're moving into territory that isn't supported by the authority we cite, and I'm not sure where we would come out on that question ultimately. Like, do you have to, on breach of contract, fraud, that kind of thing. I don't know. I just think in the context of this opinion and the facts, this makes sense.
I think that we would have to recirculate them over the.
I'm sorry, I can't hear you.
We definitely have to recirculate for comment. Right now, I'm not feeling, and maybe we still do, just based on the yellow sentence, but.
Oh, you mean if we change that first sentence? to
Yeah,
take
I
out
think
malpractice?
I think everybody's gonna be interested in that and wonder whether it's correct.
No,
I'm definitely giving a hyper-technical reading to it, for sure. And the average lawyer reading this, or average person reading this, probably would not see that. And I do agree that that formal opinion that we cite there talks about a malpractice claim. So it is not incorrect, that first sentence. But, and you're right, we can capture it further below as a general legal claim. So if everybody's comfortable with that, that's fine.
But to be clear, I mean, the first sentence has not been changed, right?
Right.
Okay, so that's the same. It's the middle of the paragraph that's been changed.
So, I mean, personally, I am, because, I mean, what's the risk? The risk then only is that someone would read the first sentence and say what? That unless it's if it's any other kind of claim other than malpractice, I have no obligation to disclose the facts. Which I think is unlikely in the context of the.
And that's not what it says. It doesn't say.
But that's the danger. That would be the danger to me of not doing that. Weighed against opening it up. And as Steve said, I don't know what the answer to that question is, but I think he's right. Whatever it is, we'd have to recirculate for public comment. Not that that means we couldn't do it, but I just don't know that we need to go there. But hey, I'm one out of many, so what do other people?
As am I, so.
What do other people think? Should we do a straw poll or?
What are the guidelines on when you would have to recirculate the opinion, like depending on what types of changes were made?
So if they're substantive changes, which is obviously can be subjective, but certainly even the change in, I mean, this first sentence is going to, I would require that the opinion go out for additional public comment. That is substantially different than what the opinion said previously.
I think the answer, if I'm right, is there isn't a black and white kind of guideline. The general notion is if it's a substantive change, it goes back out, right?
That's correct. Yeah, you added a new, so the easy ones, you added a new case citation or a new rule. You added or changed an obligation which was either previously in the earlier version or not in the earlier version. But those are easy ones. Similarly, on the other side, which are easy, grammatical, non-substantive changes, things that provide further clarification, do not need to go out, for public comment.
Those sentences in yellow were meant to provide further clarification on that point. I'm not sure we're saying anything different than we were the first time, or what we meant to say the first time. We were just clarifying that. But.
Well, I understand what you're saying, but an attorney is always permitted to suggest, and may be required to do so, was not in my view, not reflected previously, and I think we'd be subject to criticism if we didn't circulate for that issue alone.
Well, I mean, I don't think circulation should drive our substantive working opinion in any event. So, but I mean,
and then.
So what? I mean, is there any consensus here in the first sentence in terms of, I mean, who thinks that it's important that we address this issue of potentially broadening the first sentence and not having legal malpractice claim because it's too limited? Is there anybody who feels strongly? Kendra, I think you would be inclined to do that. It seems like.
Well, I see it from two perspectives in that first claim, or that first sentence, directly cites that formal opinion, which is based on malpractice. So I'm comfortable with leaving it in based on the fact that that's what we're citing as the authority for that. So we're just laying out what is presently
That's right.
in existence. Right?
And then when we get to the next section, we're not specific to legal malpractice. So I'm comfortable with that. Is everybody okay with that? Okay. All right. I'm trying to remember where we got.
Kendra.
Oh, yeah.
Well, we were responding to
Okay,
comments
good.
from the related to the LA County letter, and they were discussing the fourth paragraph, which led us to discuss more issues related to the fourth paragraph.
I guess I'm going to throw one thing out there, even though I don't strongly, I'm just going to make a suggestion. I think when we step away from this,
Sorry.
that's okay. We say, the first things we say, you have to disclose the facts. And then we say, you're always permitted to do something. I think the reader who's not in the depths of this discussion, it's going to be weird to sort of suggest something that you're not, suggest that you might be limited. I guess, let me start with my conclusion, which is, I wonder if we want to flip the order of the two sentences in the middle. So we would say, you can't give legal advice, but you can do this. Because it seems a little, I think it's going to be hard for people not in the middle of this discussion to understand.
I think this is a good
Or what
suggestion.
if we said, another option, although I like yours too, I was having trouble with that sentence too, to say the duty of communication requires, and then the next sentence is, the attorney may also be required to, have that be the next sentence, depending on the circumstances, but you say, but they're permitted,
Right.
just to reframe that, the second sentence to kind of go with the language that they're required to do this, they also may be required to do this depending on the circumstances, but they're not permitted to do the final conclusory sentence. I don't know.
The idea
Kinda
being
like-
that they may also do whatever, which wasn't in there already.
I think because we're not elaborating on the circumstances where it may be required, I kind of like Amy's, where you say you're required to do this, you can't do this, you may do this and may be required in limited circumstances to do this. Because the 2 points we want to make the most clearly are you have to disclose the facts, and you absolutely can't disclose the conclusion about whether there's a claim.
Right, we all agree
So
on
I
that.
think if we do those in that order, that makes the 2 key points, and makes them strongly. And then we say, a lawyer, can always say the following, and in some circumstances, maybe will be, not maybe, but, might have to. I just like that flow better.
And then do the citations, after that, confuse that concept, because the citations really support the first sentence.
Yeah,
No, you're right.
so should the citations go after I would recommend they go after the first
Before
sentence.
the however.
Yes.
Attorney may also.
All this.
Yeah.
I wonder,
Because it is true, you're talking about, you have to disclose the facts. You may also disclose that the facts may give rise, however, you can't do this. That also kind of floats. And then also, you're not breaking up 2 sentences that go together with the large. They both work. I know.
Should we either put however here instead of here? Because you're required to do this, but you're not permitted to do this.
Boy, we gotta decide which way do you wanna go. Are we abandoning my approach and doing the other, which is fine? I mean, right now it's saying you must do this, you can't do this, and then you can and maybe sometimes have to do this.
Yeah, I think that however the attorney sentence should go.
You think that should be?
But it shouldn't start with however, it should say, the attorney may
All
also.
right, let's do that. See what it looks like then.
Let's try to do this.
Right, because I think those 2 sentences should go together, I think
Yeah.
they're.
sorry, say that again, Dina, so maybe we can hear you.
The attorney may also be required to suggest and use that same language, and then I guess it could end depending on the circumstances, although, as opposed to, and in some cases, it may be required to do so, but I was just saying, have it start with may also be required to tell the client, I mean,
Right, suggest.
Yeah, to tell.
Depending on the circumstances, those would be right.
So delete this part.
Right, and say depending on the circumstances.
No, front to front, in front of a church.
I would say tell instead of suggest.
Yeah, now I can go back up. I think it works better now.
You know, the first comment is gonna be, what circumstances?
I know.
Exactly.
Tell us what
That was my
circumstances.
point of putting it in the middle. You're highlighting.
It's coming anyway.
No, it needs even up one more.
Now it's going back to
Well,
four.
when you say more, one question, I think Andrew's posing the question, not permission rise, but paying on certain may also be required to tell a client the fact to give rise to a claim.
Such as.
But, for
Hanging there.
an unsophisticated client may be unable, without such a suggestion, an unsophisticated client may be unable to appreciate the importance of what they're being told, or the significance of what they're being told.
Of the facts.
Significance
Of the facts they are being told.
To understand
The significance.
Of the facts they are being,
Of the facts that have been disclosed.
yeah.
that have been or are being.
Guess we could just say facts.
Of the facts, period.
Facts disclosed.
And now we, however.
I would say, how about, for example, without, unless an unsophisticated, what did required to tell? Why don't we say, may also be required to state that the facts, and then without such a statement.
So instead of tell, state.
And I'm just trying to, I'm using the state as a way to get a little bit more of an explanation here, without such a statement.
I don't think you need state to get to statement.
Okay, well, so how would you change it? No.
I like tell because
Okay.
otherwise it feels like we're telling the lawyers they need to insert some
Right.
boilerplate language. You may have a claim against me.
To tell the client, take out the second two.
Do we need the introductory clause depending on circumstances, since it's, we're saying the attorney may also be required. What do we mean by, and it creates potential ambiguity, because although we're providing an example, that is but one.
That's the question.
I don't know. I think that people could go the other way of reading that too
I like
strong.
depending on the certain, I don't know, I like the fact that we're not saying it's all invariable.
That seems inconsistent though with the conclusion. Why would it depend on the circumstances? You'd always have to tell them about the facts.
No,
What
it's,
am I missing?
This is telling them that the facts may give rise to a claim.
What do you mean, depending on the circumstances?
You don't always have to say, hey, by the way, that may give rise to a claim for malpractice.
Oh, okay, fine. But the following clause doesn't say about the may claims. The attorney may also be required to tell the client that I see, facts may give rise to.
Right. It's that extra,
Sorry,
that it
sorry,
may
sorry.
give rise to a
Yeah,
claim.
yeah. That makes sense.
Still no appetite for creating a new paragraph.
It's still only
We want it to be a page long.
You could break it out however.
We're telling, these are the legal principles, the applicable principles.
it's the citations that are, it wouldn't be a long paragraph.
Right.
Yeah.
I kept
How about
citations
footnoting
and footnotes.
such as?
I think that's actually a good idea. It becomes totally unreadable
Footnotes
to
is
put the
idea.
citation in footnotes.
All of them?
No, hold on.
It's a good idea.
Oh, including others, authorities generally support.
Oh, no, wait. I would put it, maybe just the one, just the Colorado and maybe just those. It's not for, I don't have any scientific reason for doing that. Because I do agree it's kind of hard to follow.
And those are two
And
out-of-state
those are
authorities.
pretty, yeah.
They're not out-of-state, so who cares? They belong in the state.
Exactly.
Now it reads like this. I know, right? It's the weight size paragraph.
Yeah, that's our measure.
Yeah,
Get on the
yeah,
screen,
the
it's
paragraph's
damn
too
long.
That's right.
It seems a little odd, are we seeing the right thing when we say the attorney is not permitted to advise whether a claim exists? Is that exactly right, or it's whether a meritorious claim?
That concerned me as well, because, you know, what if the attorney wants to fall on his or her sword for some reason and say, you know what, mea culpa, I am wrong, you have a claim against me. Can an attorney really not say that? Or is it more that we don't want attorneys advising about the nature or merits of claims?
It's
Because
tricky.
it happens.
You say, I'm
Not
gonna
often.
fall on my sword. How hard are you gonna fall on your sword?
Well, sure.
Right, you know?
Sure.
And what damages are you gonna make? It gets pretty iffy.
Right, well, and I agree with you. How do you cabin that?
No, but I mean, I have seen lawyers that have said, I made a mistake and, you know, you probably have a claim, or I think you have a claim. I mean, I could see a lawyer being willing to say that potentially. I mean, your question is, you're, you know.
You can't say just that.
Technically prohibited from saying
I
that.
made a mistake.
Well, the language we had before was that they weren't required to specifically disclose the,
Legal.
that the client may have a legal malpractice claim against the attorney, because to do so would provide that legal advice. So we didn't, this is stronger than what we said before. In other words, we're saying now they're not permitted to.
How about how the attorney is not permitted to provide legal advice to the client on the merits of the claim?
I think that's better.
I mean, that allows me to tell you
Right.
just
It exists
generically
where
what I
that's
think
the
the
problem.
claim, but the point, I think, in the authorities is I shouldn't be counseling you.
So
Exactly.
Sort of
we're
moving.
already
That's-
correctly using the word advise. So we want to make it more clear by saying, provide legal advice.
That's already in there, yeah, just take out.
Here,
So however, the attorney is not permitted
two.
to provide legal advice to the client.
Claim or about the claim.
As to the merits.
About any claim,
About such a claim.
or about such a claim.
But that does still go to, I think, Justin's point, that if someone says, look, I made a mistake, sue me. You know, that appears to be
Yeah,
a
but that's not
conclusion.
really providing legal advice. I mean, the point is,
Sue
you
me?
sh- huh?
If you tell them you should sue me.
Yeah, that
then
sounds like legal advice.
Well, that one I've never heard. I've seen the lawyer that says, I made a
have.
mistake and you
Right.
may have malpractice
I
claim.
have
I've never
heard it.
seen sue me.
I have heard it, believe it or not.
No.
Doesn't stop a defense from being mounted, but I've heard it, and, you know, I don't think that lawyer was ethically prohibited from saying
Right.
assumed.
I've
You know
also
what?
seen
I
where.
don't think it
You
was
know,
smart.
This
So-
is about,
so
I
how
want to
does-
say,
how does- so
I want to
you're saying-
say,
Is SUNY.
well, we don't want to get into this, right?
Well, or is,
But, and maybe I was tuned out for a long time, but the kind of thing you say, your insurer will never let you say. And blow your coverage if you say it. So, you know, because most clauses, you know, most insurance policies regulate your ability to make admissions along those lines.
Are we gonna take the legal advice out here?
Right, we didn't finish that. You were gonna say on the merits of the claim?
They also be required to advise the claim, provide legal advice to the client. I mean, what if we said provide legal advice to the client on the merits?
you have to finish that clause.
On the merits of any.
On the merits of such a claim.
Can't you just take all this out and say because the attorney's interests were squarely conflict, do you need, you know, medicine, or do you?
I think it's helpful to be a little more slow and
Okay.
into that.
Required so
So good. By doing so, an attorney's interests squarely conflict with the client's.
I agree. I mean, I think we get it, so we should this paragraph.
Yeah,
I think
I think.
we need to make the point.
I think if you tighten it up too much.
The duty of communication requires the attorney to disclose the facts giving rise to any legal malpractice claim against the attorney. Depending on the circumstances, the attorney may also be required to tell the client that facts may give rise to a claim. For example, without such a statement, an unsophisticated client may be unable to understand the significance of the facts disclosed. However, the attorney is not permitted to provide legal advice to the client on the merits of such a claim. To do so would be to provide legal advice to the client on an issue on which the attorney's interests squarely conflict with the client's. I think that's right conceptually.
The question is, do we need a citation to your authority after where we say the attorney may also be required to tell?
Well, I think the citation would just be to,
Probably something different, significant,
right, yeah, it would be like 500 or,
and
yeah.
something defining it like, you know,
Then that begs the question, why
significance
not
about.
disclose it every time?
Because the point is that you need to disclose it if it's not gonna be already understood essentially.
It seems too cute by half. So it's gonna be subjective for the lawyer to say, client A is not gonna understand, but client B may, and so I don't have to disclose that these facts may give rise to a claim to client B, but I do to client A. Why wouldn't?
I think that's handled by lawyers making a risk assessment. You've got a sophisticated client, you know they're gonna
I just
understand
think-
it.
I think it's the scope of the duty to communicate
Right,
is.
well, you have to make the client understand.
Right, it's a significant development and you have to disclose enough to let the client understand what they need to understand. And what you have to actually communicate is not the same in every single circumstance. The other thing is that if we were to say that it has to be disclosed in every circumstance, that would blow the lid off of for sure the LA, for sure PrEP, and probably the San Francisco bar. I mean, it's very hotly debated that you have to in every circumstance.
We have no authority
We
for that.
probably wouldn't want to stake out that position.
Hey, I'm
That's
on that
just-
view. I agree. I'm just saying,
Basically,
I think-
in order for the communication to be complete,
should we give
sometimes
more
you have to
description?
say,
Oh, I think it's pretty easy to figure out what's going on here, because the sentence says, the issue is, you have to disclose enough that the client will appreciate the significance of what they're being told. And that's certainly implied in our example.
What if we said like certain clients instead of an unsophisticated client? I don't know. Just because there's this notion that you want to feel as an attorney comfortable that you felt that your client appreciated the significance of the facts that you were disclosing. So that could not necessarily mean the difference between like an unsophisticated versus institutional client.
That's a good change. That's a good change, because sophisticated clients could be people who are unrepresented by lawyers and don't necessarily get it.
You could also not get it in a particular circumstance for some reason.
Right.
I mean, you might have a sophisticated client, you still have to, you're not really.
Certainly. Right. Or they could be operating in a kind of an emotional state where they're not taking it in. You need to bring it home in a way. I think that's good. That's a good change.
May not be. Isn't it may not be?
But can I just make we say certain clients, for example, with that? How about certain clients, for example, may not be able to understand the significance of the facts disclosed without such a statement?
I'm beyond be able to process information.
Without such a statement, is that for example? Or you want to move it?
You want to put, yeah, certain clients, for example, may not be able to understand the significance of the facts disclosed without such a statement.
For example, at the very beginning is throwing me. I'm not changing the substance, I'm just trying to change the
Actually,
flow.
should stay together though.
Yeah. We've certainly made great progress. I wonder, I mean, for me, this is a thorny issue. I mean, so other people feel like this is clear. And I totally appreciate that and defer to those points of view. I just want, and we are close to possibly voting it out here, sitting here. I just wonder if maybe the drafting team wants to take a considered view of making this clear.
My next question to you was going to be based on what you said. It sounds to me like even if we had total agreement and parse this down to a final vote, this thing's going out again for public comment. And so I think we've captured the concepts that we've discussed at length, which I think has been helpful and productive. But instead of trying to parse the language, I mean, maybe we should take sort of what we have here and have the subcommittee look at it with some fresh eyes, and then next, meeting we can vote on the final language, and then I think we will be voting it to go, and it will have to go out for public comment.
The thing is, if we didn't hash this particular section out now, we would have to have done it the next meeting anyway.
I agree.
Because everyone just keeps on having new suggestions.
Yeah, this
kind
was
of good that we went
useful.
through this part.
Oh, yes, no, I'm saying it's time well spent now, but at this point, we're at a diminishing, I think we're down to a little I'm reversing where the for example goes, so why don't we do that? We'll go ahead and the subcommittee, between now and the next meeting, the subcommittee will look at this, we'll look to be, we'll look at it again as a group at the next committee meeting, and hopefully if we have consensus, we can vote it, and it will go out, it sounds like almost assuredly, for another round of public comment. Whatever that changed language looks like.
And this is going to Amy?
Yeah.
Okay.
And what I understand my task is we're going to review this thing that we worked on intensively, plus I'm going to implement LACPA's technical sort of grammar and things, and I think I'm not going to make any other substantive changes based on any of the letters.
I think that's right.
Cool.
All right. It's only 1 o'clock.
One down. Two. Forgot the letter.
That's all of our
Andrew.
We off the record?
Andrew, don't you think this is a good topic for the
Yeah, you can pitch it when we get
symposium?
back.
Are we off?
It's a winner.
So we, no. We should say what time we're coming back though, in case.
So, okay, we're going off the record
Pass
at
this one.
1 o'clock, and we'll be back from lunch at,
2.
what, 2?
Yes.
Yeah.
All right, see you at 2.
That's a lot of time, but all of our opinions are important, but this is an important opinion. And that, those issues are, so anyways, I think it was worth it.
That's very.
But I want to opinion, are you any happier with it? You don't look any happier.
Well, I'm just sorry that I created this mess. But
No,
You did.
I will say that
Lots of people.
my comments were very small, limited at first, and it just kind of snowballed.
it's typical.
Okay, we're gonna reconvene our committee, it's about 2 o'clock. I wanna move now to 14-0003, which is the settlement, or settling before withdrawal opinion. And Suzanne's the lead drafter on this opinion. Suzanne, you wanna just briefly tell people what's changed since our last meeting?
So since I think actually the last meeting we didn't get to this one, but then
Oh, that's right.
the one before, we had some discussions on refining some of the language in this one. But there really was not a lot of substantive change. It was some organizational issues and sort of cleaning up some things, moving some things around, and tightening up some language. So I think we should be pretty close on this one. I'm really curious to see what, comments anyone has.
And I think actually the last time we did discuss this, which I think you're correct, was not the last meeting. The meeting before that, we thought this was really close and said everybody look at it, sort of fine-tooth comb. And so we should get everyone's comments and let's take them, because this does seem like it's pretty close to potentially getting a vote.
Okay, and so also on the subcommittee are Amy and Joel and myself. I have some comments, and you want me to go first?
Yeah, I think Amy she might have additional ones, but Amy had given
During
me a
the
draft,
subcommittee.
and I incorporated
Yeah, okay.
whatever.
Okay, so my first comment is in the digest on line 22. I think we're missing a word between during and settlement. It should be provided that during the settlement process, the attorney does not make false statements. Over on the second page on line 71, this paragraph ends with a cite to 3-700B, and then the next paragraph picks up with the fact that 3200 has language similar to B1. I thought it might make sense on 71 to have the cite be 3-700B 1 through 3. You know, paren 1, close paren dash, paren 3, close paren, because we're really enumerating all three of those in that paragraph, and then the next paragraph is saying, hey, the B1 language is the same in 3200, so just a minor thing.
Yeah.
Over on page 3, the subheading, it says attorneys' ethical duties to clients are not diminished because attorney has concluded a client's case lacks merit. I just thought about this, and maybe this is too technical, but I was sort of wondering, is that entirely true? I mean, the duties, you still have duties. clearly, which is our point. But are they not diminished, like, in any way, shape, or form? I mean, it seems to me if I have a client and I come to know that their claims are meritless, to some extent, what I can do for them in terms of advocating and things like that is diminished. Maybe it's too picky, but my fix would be attorney continues to have ethical duties to client even though attorney has concluded a client's case lacks merit.
Yeah, I think
It's
that's
just
fine.
it's just the diminished concept kind of caught me a little bit.
Yeah, I think that's a fine, I don't think that the ethical duties are ever diminished,
Okay.
but I'm perfectly fine with
I can
suggested,
live with
yeah,
either.
change.
So is it like this?
Attorney continues.
Attorney continues to have ethical duties even though attorney has concluded,
Clients.
and pick up the rest of, has concluded the client's case lacks merit.
Should it be a client's case, because I think we're using,
Yeah, no, get rid of A. Has concluded the client's case lacks merit. Okay.
yeah.
On this same page, down on line 126 and 127, so we make this point that in the matter pending before a tribunal, the duty to take reasonable steps, avoid reasonably foreseeable prejudice lasts until you're either substituted out of the case or you've been relieved as counsel by order of the court pursuant to a motion, presumably. And then we say, in such a matter, even where mandatory grounds exist, withdrawal is allowed only with permission of the tribunal. And then we say, if neither substitution nor permission to withdraw is granted, the attorney must continue. That middle sentence, I'm just wondering, number one, do we need it? And number two, is it a little confusing? Because, I mean, a substitution technically would get you out, and I don't know if that's, I mean, that's not an order of the court. Is it permission of the tribunal? But I just don't think we need that middle sentence. The point is, you can't get out, as we say, until there's a formal substitution or you've been relieved as counsel, and if neither of those things happens, then you're in. So I would just strike the sentence at 126 that says, in such a matter, even where mandatory grounds exist, withdrawal is allowed only with permission of the tribunal. I mean, we've already said it. We just said you either have to have a substitution or you have to have a court order.
I think the point was to say that even though it's mandatory, you still have to get permission, but I don't think that prior sentence says it, but
I don't think so
I'm not
either.
sure it matters.
It's a new idea.
Well, okay. All right, so
So maybe you could say, in a matter pending before a tribunal, even where mandatory grounds exist,
I think that makes sense. That captures the added point, but and seems less.
So,
Hold on, what did you mean?
in matter pending before a tribunal, so up on 125.
I'm looking at, oh, sorry, I'm looking at the wrong sentence.
Yeah. So, in a matter pending before a tribunal, comma, even where mandatory grounds exist, mandatory grounds for withdrawal exist,
Right.
comma,
The duty to take reasonable steps.
and then just take out this, in such a, the sentence that follows.
Yeah, that works.
Yeah, that's a good point. And then, so, meaning those changes to that sentence there, reverse those. To the last sentence that says, if neither
Yeah.
substitution nor permission to withdraw, that should say the same.
What do you want me to reverse?
Oh, I thought, wait, let me just, I forgot.
We
it's
deleted
red
this
line.
sentence 'cause we-
Yeah, that's fine.
Oh,
Sorry, I saw the red line.
it's okay.
All right, the next comment is on page 4. Footnote 2, which is the cite to Zamos. My only question was, would it make sense to move that to the end of the next sentence?
The end of the paragraph, in other words.
It seemed kind of disruptive. I mean, we're discussing Kirsch, then you jump down to this big Amos, and then you go back to the point that, you know, the rationale of Kirsch. So it might make more sense that Kirsch, then the rationale, and the end of the paragraph have the footnote. Yeah, just moving the footnote.
Yeah.
The
So
substance
move that.
of it is.
Footnote 2 to the end of, to follow the id.
I mean, I'm being.
No, but that's a good point.
And then on line 154, where the sentence that ends, the client's interest remains,
I think it should be remain, just start the S.
This is really my only somewhat substantive comment, and I'm not wed to it, but I'm just going to throw it out there, and because I know even if we keep this, Amy has a suggestion on a language issue too. But this last sentence, this may include advising the client as to the risk if the attorney withdraws that an adverse interest may be drawn by others if the case lacks merit. So we're saying here that there may be an obligation in the withdrawal context to be telling the client that an adverse interest may be drawn by others by virtue of the withdrawal that the case lacks merit. And this shows up a second time in the conclusion, where we talk about the steps for avoiding reasonably foreseeable prejudice. This is at line 242, and we're listing the things, and we say it may include, the steps may include delaying withdrawal to allow the client to attempt to retain other counsel, advising client of the risk that non-consensual withdrawal may create an adverse inference that the claims lack merit, continuing to take the steps necessary, et cetera, et cetera. So that concept's there twice, and I just raised the question, I raised the question is that something that you're obligated to tell your client? I mean, in this particular opinion, or are always obligated to tell them. This opinion, we're looking at the issue of may you seek to settle the case? Is that ethically permissible even if you think it lacks merit and you're going to have to withdraw? And the question is just, if I want to pursue settlement and I can do that in a certain way, is it permissible, right? And I think we've said before that we don't want to stake out a position in this opinion that suggests that there's an affirmative obligation necessarily for lawyers that have a case that lacks merit to nonetheless see if there's some way to settle the case. I mean, I think we had that discussion before and said we're not at that, we're not going to say that automatically in your checklist of things with the case that lacks merit is you got to go and try and see if there's a way to settle it before you would withdraw. And so we don't want to say you have to do it, but we're looking at whether you can do it. And I think, I mean, to me, I have a question to myself. The note to myself was, does this go too far? I mean, do we need to say this, and does this go too far? I mean, it could suggest to someone that you're obligated to tell them that, your filing of a motion to withdraw could be perceived negatively. It actually says something more specific than that, which is, I think, not correct, which is it may be perceived as being based on the lack of merit. I think actually in most cases when a lawyer files a motion to withdraw, 9 out of 10 times, the inference is going to be drawn is that there's some kind of fee issue. Not necessarily, I mean, it's a leap to say that, because I file a motion to withdraw, the other side is necessarily going to think that your case has no merit. So I think that just factually I don't agree with. But the broader issue is, you know, we're saying it here, and then in the conclusion, we're listing it as steps, you know, to avoid reasonably foreseeable prejudice and to the client. And I don't know, but how do people feel about that? I mean, do you always have an obligation to say, hey, if you force me to file this motion, it could be perceived in X, Y, or Z negative way?
Suzanne,
So-
I had a question also, which is triggered, and maybe it's efficient to put it in, which is, the thing that struck me as the thing you obviously have to advise them is that you can't continue. That given the state of the case, you ethically can't continue, and probably wouldn't you have an ethical? Would you have an ethical obligation to tell them they have to withdraw the case, take up dismissal with prejudice? I mean,
Well,
I'm just
that's
wondering.
interesting.
I'm a little scared about what we're getting into here. In other words, there's a set of questions, and I don't have clear answers to them, but those are at least as clear to me as the duty to warn that there's potential prejudice.
Yeah, so a couple of things. One is the conclusion that the case lacks merit, that comes from a case.
It's Kirsch, I know.
Yeah, so
Because the
that's
lawyer
why.
didn't give the opportunity for
Right.
its new counsel to be obtained.
Right, and so that's where we're picking up that language from the case that says, you know, the inference may be. But I don't see.
But can I just real quickly?
I want to get oriented to where you're saying, because I see what you say in the conclusion, which says, you know, those steps may include, and then there's a list of stuff. So I don't see how that's telling somebody something they have to do. But then you also pointed to something in the text, and I didn't follow what you were pointing at in the text where we said it. So do you mind just
Yeah,
telling me?
154, 155, that's
Okay.
what a Kirsch is.
And so, my recollection is this language was added from our last discussion, and Steve, I actually think, because it was a good suggestion that, you know, aren't some of the things that you have to disclose that, and then, so I incorporated it based on our last discussion that people thought we should maybe give a little bit of guidance about what maybe you could do to prevent adverse consequences, and that maybe advising the client that there's a risk. So we added that based on the committee's thoughts last time. I'm fine, you know, taking it out or talking about it again, it's fine. And I agree, we don't necessarily want to get into an exhaustive list of what you can or can't do, but certainly I don't think there's any intention, if it's there, it should be removed, that you must do really anything. And every situation is so different. But I do think it's helpful. I think sometimes we try so hard not to stake out positions that we end up not giving a lot of guidance. Like, let's give attorneys some ideas for what they can do, and it may include trying to settle. That's a good point, you know, Steve. It may include telling them, you know, I have to withdraw. I mean, I think you're telling them that anyway. I'm not sure that the client has an obligation to withdraw their case.
I'm not sure either. I'm just
Well, and actually, not the withdrawal, but I mean, and again, there's two places. One is 154, 155, where we're having this discussion of Kirsch.
I want to mention this concept.
The second is in the conclusion, and the conclusion really is this: let's give some examples of how to avoid reasonably foreseeable prejudice, and it does include advising the client to dismiss the case. That may be one of the things. It doesn't say I may have to stop representing you. But maybe it makes sense to, I mean, I just think, at least as to the first location where we're discussing Kirsch, I mean, Kirsch, yes, they said an adverse inference could be drawn in that situation, but wasn't the criticism that the lawyer just filed the motion without giving the client any opportunity to go get other counsel?
The language from Kirsch that's quoted has nothing to do with those particular facts. I don't think that language just says that when an attorney non-consensually withdraws, it's an obvious inference that it's not for the client's purpose.
Yeah, okay, so it's not even as specific as to.
Right, it's just sort of a generic.
I mean, I would be in favor here where we're discussing Kirsch. I don't think there's any reason to throw a laundry list, or B, even more so, pick one thing like advising that, you know, could be an adverse inference about the merit. I just don't think it needs to be here, quite frankly.
I have to agree with Drew, and the other thing that bothers me a little bit is that this almost appears like an attempt to pressure the client to give a allow consensual withdrawal. And so it almost gives an impression that, you know, if you're not familiar with that case and the circumstances of that case, and you're looking at this opinion without that familiarity, it almost looks as if there's some pressure that somehow will be put on the client. You consent to my withdrawal, or you consent to the way I handle negotiations from this point. And I don't think you want to say that. I don't think it's necessary to say that. I think that the case is kind of specific to its own facts, and I think that enough of those facts will quite be included. That it's not something that we have to be specific.
Well, I felt like we were using it a little bit to justify that it's okay to do settlement, like, because we could tell them that, you know, that it might be adverse to force me to fight. I mean, I just don't think we need it. But anyway, I interrupted you.
Yeah, so I mean, the overall, to take a step back, like the overall purpose of discussing Kirsch and the other case are to talk about the fact that where you decide that a case lacks merit, the case law doesn't let you off the hook. So that's really the overall point, is to talk about you still have obligations. Here are cases that say you decide it lacks merit doesn't mean you can drop the client like a hot potato. Here it is, you know, you decide that the case lacks merit, and not only can you not drop, but you have to wait. So that case is actually anticipating that there's going to be this time frame between you deciding the case lacks merit and sometime in the future where you're withdrawing, because it's affirmatively saying you should give time for that process. And so the quoted language is to explain why the Kirsch court concludes what it does. It concludes what it does because you just withdrawing right away can create an adverse inference against your client. So that discussion is really in the context of Kirsch and why the court decided what it decided, which I usually think is helpful, you know, so the reader can orient why that case decided, you know, what they did. And so knowing those facts, you're right. We're supposed to be, you know, looking at the issue, can you settle? So to some degree, I guess we don't need to talk about the foundation for the Kirsch conclusion, but I think it's a little bit relevant to the opinion because it does show that you still have duties. The courts, both of those cases stand for the proposition that you still have duties after you decide a case lacks merit. And so talking about what those duties might be, I certainly don't think it's harmful to suggest that one of the duties, you know, that to prevent foreseeable adverse consequences, you should explain to your client what those adverse consequences might be, which would include, hey, by the way, and I don't know, I mean, I haven't withdrawn very often, but I would say that if I were, I certainly would disclose to my client, look, if I file this, it's not going to make you look good. It's either going to make people think that I've lost faith in your case, or that we have a fee dispute, or whatever. So, I mean, I don't think it's necessarily a bad thing to suggest it's one of several things you could do. But I think we added this because the last go-around, people felt like we weren't giving people enough guidance about what they could do. So,
I think Amy had her hand in there.
I was just going to clarify that I think I understood Drew's comment. It's not a suggestion that the discussion of Kirsch, the facts of Kirsch, and the court's analysis be cut out. Because I agree that that's, well, in my view, it's very helpful. But I think the suggestion is that then we don't need this sentence from 154 and 55 that sort of kind of says exactly what Kirsch says, and says that may be one of the particular ways in which this duty to avoid prejudice manifests. So just to make that clear, because I mean,
I'm
I'm not saying take out Kirsch or the quote rationale. I'm just focused on the last sentence, and even to be more specific, if we wanted to leave in this concept that among the list of things you could or might do would be advising that, you know, the filing of a motion could be perceived in a negative way, that could still be in the conclusion. It seems odd to me here after Kirsch to throw in this one, you know, if we're going to do it, let's do a laundry list of mays not required right in the conclusion, but it just, I don't think we need it here, and it seems odd to throw it out there. Yeah.
So that, I agree with what you just said, Drew, but to the extent that we do weave in some type of discussion similar to 154 and 155, where I'm hung up is the phrase adverse inference, because I think that has a particular legal meaning, and so we should consider a different way to articulate that.
Amy, I think, shared the same. So that's just a language thing. We got to find something to say other than adverse interest, because adverse interest is a loaded term, I guess.
Well, in the paragraph that's following that, there's a description of what happens when the attorney withdraws, and that there are these consequences that the client's going to be potentially facing, which is why settlement, you know, could be a good solution if it's possible in this case, and maybe there's an opportunity to discuss, like, these are the things that you would also tell your clients, or what are things that are going to happen in the case in terms of the suggestion that you want to, you know, Suzanne, you were talking about wanting to make sure that they understood there's consequences to what's happening right now, and here's some of the consequences that are happening.
So are you thinking something after the next paragraph would be more useful to say these might be among the things you would disclose to your client or something?
Yeah, that's where I think that could. I sort of agree that with removing that sentence and the way it's framed there, but I see your point, and I think it's an important one that you want to, you know, just reiterate that you are discussing with your client that there are consequences for your withdrawal, and these are among some of those things. I mean, that's why the suggestion is that settlement would be okay if it's possible to settle the case, right?
Right. So maybe it's something at like 162 to 163 where we say, you know, these risks to client could be avoided or mitigated through a settlement of the claims. We say something like these risks to client may also are also among what should be disclosed or something. I mean, my recollection of where this is coming from is that in the and again, this is incorporating some comments from somebody else from the last time, so I'm trying to recapture that.
Sure.
But my recollection is that in the conclusion, we did give sort of a list of things you could do, and that seemed to come out of the blue. I think that we gave the list in the conclusion, but in the body, we didn't give the any kind of list or like where are these things coming from. That's what I think. So I think I was trying to go back in and find places where we could weave in this suggestion, and maybe that's the wrong spot for it. But I think that's my best recollection.
So I guess I have a concern, which is, I think I started to hear from Drew, which is, let's not, the point is that the duty to avoid foreseeable prejudice is what makes it justifies the notion that possibly you could settle a meritless case. Which initially, I think the idea of this opinion is that feels uncomfortable at some level, right? Like, why should your client get a release when you know? So that's where I think where we started. And now I feel like the opinion might be veering towards how do you avoid reasonable prejudice when you've decided a case lacked merit, which is just a different opinion. And what I like about this opinion is it's very focused. And so I think that the criticism that the conclusion suddenly gives us a laundry list is valid, but I don't think the answer is to add it into the body. I think the answer is to consider taking it out, because our point is one of the things that you could do because of the duty not to avoid prejudice is maybe settle a case.
Right, and so it's a good point, and now you're reminding me of how the other stuff got in there, which was, to Drew's point earlier, we don't want to be telling people that they have to try to settle the case. So there was a lot of concern about, so if you go and say, you have to, you know, you can do it, and then, oh, are we suggesting that you have to? So then the dialogue goes, well, no, you can do that, or a bunch of other things. So that's so we're kind of going, flipping, you know, between these two. We wanted to make clear that we're not saying you have to try to settle it. But we also wanted to, and so to do that, we thought we'll talk about some other things as well, but then maybe now we've gone too far in that direction. But I mean, at some point we'll probably just have to say balance is struck, like, you know, we're good with it. But
I'm pretty comfortable with the way you've drafted it, that up to the conclusion, it is not telling someone they have to go try and settle the case as a means of avoiding reasonably foreseeable adverse prejudice. So I'm comfortable with that, and I do think, I mean, what you're saying makes sense. It's ringing a bell, and I can see how that got added to try and, you know, flush something out in advance for the conclusion, but it's still a disconnect. So,
right.
As Amy said, either you got to go into the middle body of the opinion and really be talking about other alternatives, which I think we shouldn't do for the reasons she said, or we got to have the conclusion section not be purporting to give a list of alternatives. I mean, she's right. It's a focused issue, and it's the avoiding reasonably foreseeable prejudice that gives you part of the foothold to potentially do this. But it's a pretty specific question. So I tend to agree with that. I think if anything, I mean, I would take it out at 154, 155, but then I think the real issue is what do we want to do with the conclusion? How do we modify that in light of that, if people are in agreement?
Well, I certainly have no objection to taking it out of 154, 155. I don't mind the idea of giving people more guidance than less, but I do agree that if it's only in the conclusion, I mean, I wouldn't say it's only in the conclusion, because all the, you know, the cases we talk about, I mean, we certainly mention these concepts, so it's not like it's coming out of the clear blue sky if we have sort of a list of the things that you could do.
Well, if we
but I
like
do know the list was out of concern that people might read this and think that they had to do it. So I don't mind taking in 154 or 155 and maybe leaving the conclusion. Or, yeah.
Well, but then, Steve, would you want the conclusion to include the one you highlighted as being of significant importance? What I'm trying to remember was that you might not be able to represent them any longer.
Yeah, well, that was one that occurred to me. I don't have a strong view about. I think we're saying just may include, so I don't have a problem with having it be a non-exhaustive list.
Okay.
I do.
We're taking it out of there again, out of the
I
conclusion.
think for sure we're going to take it out of 154, you know, out of there. Whether we take it out of the conclusion is still up for discussion.
Find the first quote.
It's at 140 to 150.
Motion may create. Yeah. I'm just wondering. I mean, it's not that big a deal to me. Well, we have the adverse inference point that Justin made. I'm wondering if we leave it in instead of advising client of the risk that non-consensual withdrawal may create an adverse interest. Is there a way to say that more captures sort of the Kirsch notion that it's just not necessarily about merit, but just it's going to be perceived negatively somehow, you know.
May be perceived negatively. Maybe perceived to reflect negatively on the merit of the claims.
That's too narrow. They just reflect negatively on the client and the merits of this case.
Yeah, maybe that's. I mean, non-consensual withdrawal may reflect
Where is this?
Okay, so in the conclusion.
242.
Advising client of the risk that non-consensual withdrawal may be perceived to reflect negatively on the client or the merits of the client's case.
I guess
Does
that's
that work?
accurate. It's long, but it's accurate.
We have to be deciding.
Right,
Or
but
if
if
you
it's there,
participate.
yeah, yeah.
Well, okay, all right, well then let's not, so that's the question. Do we want the conclusion to include a list, a permissive list of things that could be done to avoid reasonably foreseeable prejudice? Are you inclined to not want it?
Me?
Yeah. I mean, Steve, I think you've said.
I don't object, I mean, I don't have a categorical objection to it, I guess.
Right.
And I don't have I don't have a sense that if it's stated as may, I don't have a sense that it has to be exhaustive.
Okay.
I'm in favor of not doing it. My reason, I'm such a poker face now. We state the issue as may the attorney ethically settle the action, right? And so our conclusion, I think, should answer that question.
I don't feel super strongly about it, but I think I would lean towards keeping it in from the sense that I think it just gives context for this is the option and you have, and I may be inclined to take out that new sentence, but the new phrase in there, but I just feel like you're saying that it is talking about how to avoid prejudice. These are some examples. The one we focused on is the one we end with as an example, and then we go into making sure that they handle it with, not making false statements, and I think it gives you this idea that there are things that you can do, it's important to do it, this is one of them, you don't have to do it, and the other ones are kind of obvious. So I don't know, I just think it gives some context and it's more helpful than confusing or overreaching. I agree with your comments in general, Amy, that we don't want to go off on all these tangents in the body of the opinion because it should be streamlined to focus on this particular issue, but my view is that it's more helpful in the conclusion.
I actually agree. I mean, one other thing that I think, I'm not strongly dug in on this issue, but I do like the discussion because I think it's part of the reasoning that supports our conclusion. That it's not just we're giving a list. We're saying, like, here's a case that says you can do this. Here's a case that says you can do that. Here's a case that says you can do this. By logical extension, you can also try to settle it. So it's also providing foundation. And a lot of the things that are on this laundry list, track back to the authorities that we've cited. So I think it actually supports the conclusion as well. It is kind of why we're getting there. We've got these cases that say, so you may have to wait, and this, and you can do this, and you can do that. So that's another reason why we think you can also settle a case. So I think it actually supports the foundation for the conclusion. So I would lean toward keeping it, although I agree the underlying, the new sentence, we can talk about whether or not it needs to come in or not.
Makes sense to me.
I'm okay with the laundry list. I mean, I could go either way. An easy fix, since it's non-exclusive, would be to take out the new sentence and leave the laundry list.
I'm fine with that too. So the advising client of the risk, that portion,
Yeah.
we're saying, let's just take that out.
Steps may include delaying withdrawal. Oh no, there's still nothing.
I like that better.
Like steps.
But it does kind of make it sound like it's optional to continue to take the steps necessary to preserve the claims, which it probably isn't optional. But anyway,
But could include.
yeah. That's a good idea.
Continuing to take steps necessary to preserve the claim seems
Oh, yeah, you're right, that's not.
out of place. I don't know how you can do that.
No, I think you have to do that.
Well, what does that mean? That means continue to prosecute the cases.
Yes, that's exactly what it means. I mean, if you think you have to withdraw and then you can just let the deadline to respond to discovery pass and the deadline to respond to the complaint pass, right? You can't. So you have to continue to take the steps necessary to preserve the claim, which is exactly what the attorney in Kirsch got in trouble for. I mean, the other one. It's probably not optional. I mean, my concern was like to suggest that it was optional, but I think could is fine.
Yeah.
See, my problem with it is the order of this. You have to counsel the client, encourage him to dismiss it or to allow you to settle it, or barring that, you have to withdraw.
And or.
So, yeah, so I don't, those are all equal, if you will. I don't.
Or if it's and or.
Where?
You're saying and or negotiating.
Fifth line, or negotiating. It's the order that's the problem.
Oh, I see. Yeah, and or. Just if you negotiate the settlement of the claim, you don't have to withdraw. You don't have to.
Yeah.
So it could include, for example, we could clear it.
I think it's pretty clear.
Is it appropriate to entertain some typographical mistakes?
Of course.
Yeah, can I got just 3 other comments. Then I promised. On page 5, we talked about this before, but this is where we've come out of the discussion. We were just talking about Kirsch avoiding reasonably foreseeable prejudice. That's part of what gives us the justification to think about possibly settling the case. And we say, if this is 157, if attorney here must withdraw because he is ethically prohibited from proceeding to trial with the case, any successor would face the same ethical dilemma in proceeding to trial on client's claims. And I won't belabor this, I've made this point before, but especially given the cases we cite earlier, I mean, it's conceivable that another lawyer, if we don't settle the case and we think the claim is meritless and we withdraw, and the facts say that the client doesn't agree actually with us about whatever the facts are, but we've definitively determined for ourselves that we think there's no merit. I mean, another lawyer might come in, and this is just so absolute to me. I mean, the way I would qualify it is I would say, if attorney here must withdraw because he concludes he is ethically prohibited from proceeding to trial with the case, any other successor counsel would likely face the same ethical dilemma. I mean, some other lawyer could come along. I mean, it just seems sort of like, I don't want to say, I mean, there might be some room for disagreement or something. And in one of the cases we talk about, they talk about how, even if you thought it was meritless, you messed up by filing the motion. You should have given them a chance to go get new counsel. Well, I thought it was meritless.
but the court's saying that doesn't matter, you can't just drop the client. So I would just soften that sentence with those couple of words, because it just seems so absolutist here. Like, this lawyer made a decision that it was meritless. And absolutely, I mean, if you decide that, you need to get out. I think that's right. But you could be wrong in some fashion, or there could be room for, some level of disagreement. And the facts say that the client disagrees. And it just sounds like no other lawyer could come in. Any other lawyer who would come in downstream would have no other choice but to immediately file the same motion you're going to file and or possibly settle the case. And I just don't like that. So
I think another way of addressing that, though, because what your suggested change is that if the attorney concludes that he must withdraw, blah, 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 that still isn't going to get you where you want to go, which necessarily means that the next attorney that comes in is going to draw the same conclusion. So it might be more like if here attorney must withdraw because the case lacks merit, which is a fact. If the case lacks merit, a successor attorney is likely to find themselves in the same ethical dilemma. So that suggested change would assume the fact that the case lacks merit, as opposed to being pinned to attorney one's conclusion. Because
but that's part of the thing. I mean, that's part of the problem. I don't think there's your duty to withdraw. It has to be informed by what you know and believe to a certain extent. I mean, if the lawyer, there's not an absolute. This case lacks merit. You didn't realize it, Mr. and Mrs. Lawyer, but you were under a mandatory obligation to withdraw. I mean, you have to have the lawyer is going to reach that conclusion, which is why I think in this case, the lawyer is going to withdraw because the lawyer has concluded, actually contrary to what the client thinks, the lawyer has concluded that he's ethically prohibited from proceeding. So he thinks my obligation is, under the rule now, is I need to withdraw because of these conclusions I've reached. That, and the point is valid, that the next lawyer who comes along is likely to be in the same situation. And so, it is beneficial potentially for you to think about settlement. I mean, I think that's the point that you were trying to make. I would just say, must withdraw because he concludes, so it's just concludes is the extra word. He concludes he is ethically prohibited, et cetera, and then just add likely after would.
How about just use the word may? Because unless absent something that occurred in this representation, and you've already dealt with that, you can't make a misrepresentation, you can't do anything else. So at some point, a lawyer A considered there were merits in the case, enough to bring it to trial. Right? So in that, that's the lawyer A concludes that he or she cannot himself ethically proceed. But that doesn't mean, as you say, that another lawyer would necessarily come to the same conclusion. It's not an objective standard necessarily. And so use the word may
instead of likely.
Exactly.
Well,
so what you're saying is the lawyer
that's okay with me
the
too.
client is at risk
right.
of these other things. Another attorney may come to the same conclusion, and then you're dealing with those risks.
Well, that's fine by me as well. I don't have a problem with it. I mean, may's fine. I just don't want it so definitive that necessarily the next. Sorry, go ahead.
Because you got because twice in that first sentence.
Sorry.
So you got to work on that. Because he concludes the case lacks merit. Because he concludes
he is ethically prohibited. Oh, I see.
No, wait. If attorney here must withdraw because he concludes he is ethically prohibited from proceeding the trial with the case,
right.
Any successor counsel
right.
would or may face the same ethical dilemma.
Right, that's the thing.
I don't think we can say this twice, right?
Right.
And then my very last comment on the same paragraph is, then we say, the risks to clients could be avoided or mitigated through a settlement of the claims. Again, I would just, after could, I would say potentially. Maybe, we don't know if you're gonna be able to settle the case. We go on to say that, you know, you can attempt to settle, but you gotta do it in a certain way, and you may or may not be able to accomplish the settlement through that. So I'd just add that.
It assumes, of course, that the attempted settlement would not be anything like an attempt to perpetrate fraud on the opposing party. I mean, under the facts of the opinion, nothing substantive has changed except maybe the lawyers case. The point is, you can't do anything, and I think it says that would constitute the client accepting money accepting money that would perpetrate fraud.
I'm not.
You know something, the client knows something that.
I don't think it changes that at all. It's really actually just getting more to the point that it's not a foregiven conclusion that settlement will work or that it will prevent harm, which gets to the point we said before, which is we're not telling people you got to go try and do this like it's a mandatory thing. So I would just say potentially.
I think it's fine. That particular sentence is referring specifically to avoiding the risk of potential default,
right,
entry of judgment, or a claim for malicious prosecution. So settlement, it would be the worst settlement in the world if it didn't, you know. But you're right. I mean, you could just settle it and be on really bad terms. So yeah, potentially.
So that's it. Sorry.
That's all good. That's all good.
If I could, I had 3 typographical, would be appropriate. So on line 162, sentence starts, once attorney withdraws, and you have that then. I think the then is inappropriate, you don't need it.
I don't see 162.
Yeah, on
159.
on the
on
screen.
that one.
On the draft, it's on line 159. It's changed because we. And then on line, again, on the draft, we have in front of.
Wait. I just want to pause on that, because I think
It's the then, once attorney withdraws.
right, and I think it's supposed to follow that. Supposed to follow the sentence that says the next attorney could face the same ethical dilemma. Therefore, blah blah blah. So the then is a substitute.
Oh, for therefore.
Yeah, I think actually that,
Yeah.
because you're saying this is because of the fact that another lawyer may or likely, or what, you know, we ended up on may, but because the next lawyer may be in the very same scenario, the result then would be that the client could end up with no representation. Nobody can represent this client. They truly are meritless claims. And
Can we just maybe leave the
Then it should be
the
there.
client could then be left without representation?
No.
Okay.
Should be that there. Make it there.
That's. I don't see it.
You don't think it different?
No, I don't personally see a difference between therefore and then, but
Okay, I'll
it's
make-
fine to put therefore. Like I'm not
No,
opposed
that's
to
right.
the
That's cool.
If therefore is more clear. I mean, but it doesn't really fit there, so we'd have to put it at the beginning. Maybe therefore, once attorney withdraws, then it could be left.
On line 183.
Change it or don't?
No, leave it. She's saying that then she's okay with that, so I'm leaving
I
it.
mean, is that a
Right.
good strong thing?
I perceive them the same.
Yeah. On line 182, the very end of it, now we've changed the lines here, that it's the paragraph that starts with thus under the facts presented here. There. After the end, it says competence, and I think after and should be the obligation.
Yeah.
Correct? Agreed?
Yeah.
And then finally, there's an odd little, on line 223,
Yeah.
after co-pract formal opinion,
Yeah.
there's a reverse paren there that is, I'm not sure.
We'll fix things like that.
Oh, yeah, that's kind of
Yeah,
stuff
there's
you
like
get
in
in the draft and the editing?
It's a good idea to, you know, you never know. So
Okay.
it doesn't hurt.
things.
Yeah, that's all
At 39 and 40 of the statement of facts, we talk about attorney has therefore concluded the client's case lacks merit and cite to 3700B. And I'm wondering if we create an ambiguity by not saying the case is without probable cause, since we cite specifically to the statute or to the rule, but we're referring to the case being without merit as opposed to lacking probable cause.
I don't think probable cause is the language.
Well, I'm looking at the next page. The attorney knows or should know that the action is being taken without probable cause and for the purpose of harassing and maliciously injuring any person.
Right, and then we conclude that that provision doesn't apply to our facts.
Right. The attorney knows or should know that the continued employment will result in violation of the rules or attorney's mental or physical state. So,
Right, so we're not going for the probable cause prong. Like our facts don't fit into the probable cause prong because there's no evidence that that case has been brought for the purpose of harassment. So
But-
you need both. So lacks
Right.
merit falls under B2.
but should we then specify in 40 that the citation or the requirement for withdrawal is under B2?
I mean, that's the statement of facts. We then later analyze all of 3-700B and then explain which one applies. I mean, I don't know. It certainly can't hurt. But we're kind of revealing our conclusion in the facts, but I mean, I don't think that.
Actually, if we were to say, I mean, 3700B1 does not apply, not because there's a lack of probable cause, but because of the additional part for the purpose of harassing and maliciously injuring. So on one hand, I think I get your point, which is, well, instead of lack of merit, isn't the concept seems to be probable cause. Granted, 3700B1 is not satisfied because you don't have the second half of that. But actually, I wonder if we were in, so I understand that, but if we were to import that instead of the lack of merit, if that would be confusing, more confusing to the reader, because they have to appreciate, I mean, they'll get to the point where 3700B1 doesn't apply. It doesn't apply for lack of there being no probable cause, but only, I mean, so actually, I mean, at the end of the day, the conclusion we reach is that it does, you think it lacks merit. You have to withdraw. You haven't satisfied the provision about probable cause plus harassing, but the lack of merit means that under B2, continued employment would be in violation.
I think the lacks merit language also comes from the state of Falco, and part of this opinion is trying to answer the question raised by state of Falco. And the state of Falco says, you know, we're not deciding the corollary issue of whether or not you can ethically settle a case that you believe lacks merit. So I think we were trying more to pick up that language.
Well, I totally get your point, although it's actually persuading me now that it's better to leave in lacks merit because we're not going to fall. But
it was more just a concern about creating an ambiguity than it was the language being erroneous, essentially. Okay, so then in the digest, line 25, I propose the last sentence read, that's a long sentence, the last two lines read, merits of the client's case or concealed information bearing on the merits that attorney is required to disclose to the opposing party, as opposed to, again, making it a more ambiguous statement in terms of who's responsible.
Actually, that, and I'm fine with wordsmithing it, but that the later discussion is not just about what attorney's obligations were. It was, you know, if the client has withheld documents that were relevant. So that is not supposed to be limited to the attorney. So if the client withheld documents and the attorney finds that out,
the attorney is prohibited from, not clearing that up, even though it wasn't the attorney's duty originally to disclose the documents.
Right, but isn't that, I mean, it's still the obligation of the attorney.
Well, the idea is that, what's the ambiguity that you think is created by leaving it, you were obligated, there's information that was bearing on the merits that was required to be disclosed. Do you think it's unclear as to who was supposed to disclose it?
I mean, this is obviously an ethics opinion directed to attorneys, so, I mean, the thought would be, let's focus on the obligations the attorney may have, whether due to the attorney's position or by virtue of representation of the client and the acquisition of information that is obligated to be disclosed, or in this case, not concealed, I guess.
Okay, so here's the problem, is that if your client conceals material information, you are not allowed to disclose that as the attorney. So if we say the attorney can't make false statements to the opposing party about the merits of the client's case, or conceal information bearing on the merits that the attorney was required to disclose. Well, the attorney wasn't required to disclose that the client withheld documents. So then it suggests that the attorney could go ahead and settle it even though they know the client concealed documents. So I just don't think the idea was to focus on what the attorney's disclosure requirements are.
What if you said bearing on the merits that attorney knows was required to have been disclosed by anybody? If you know your client was required to disclose something or did, and you can conceal their.
What's the ambiguity that we're trying to?
Yeah, I'm really struggling with this.
Let me read it again. I mean, I think what I'm struggling with conceptually is obviously if there is confidential information which the attorney acquires during the course and scope of the representation, can't disclose, even if it otherwise would need to be. Can't make false statements.
Or perhaps concealed information to which the opposing party would be entitled.
Bearing on the merits to which the opposing party was entitled.
I think maybe you're onto something, that this suggests, the attorney is the attorney concealing, so imagine the case where there was documents that should have been disclosed in discovery.
And the first round of discovery was therefore fatally incomplete. Now you learn.
Is the attorney, by not disclosing, because the attorney can't disclose, is the attorney who's concealing information? Is
Why
that the
don't we
issue that
assume,
you're having?
well, aren't you assuming that the client now has come forward with more documents that were otherwise disclosable?
Right,
And now there's a continuing obligation to make a record, to turn them over.
I think the issue is that we didn't want to get into discovery obligations, the differences between federal and state, the differences between, a million different applications. So we were just trying to say, we don't really care why it is that the opposing party was entitled to this stuff, but if they were entitled to it and you are concealing that information, then you can't do it.
Can't say.
Right. But I think what Amy is seizing upon is sort of maybe off of what I was just saying, which I just see now, that if what the attorney is concealing is confidential information, then that's a different story, right? Because that's not really concealment, it's confidential information the attorney can't disclose. So,
The client could.
right. So I think it's more about that they can't make false statements, or I think the idea was that if you know that information is being concealed, you can't tell the other side that you know that, but you also can't settle.
Right.
So maybe, I think it's the conceal word that is providing problem, because it sounds like the attorney is concealing something the other side's entitled to know, but if it's confidential information.
Well, that's a question, right? I mean, conceal. I wondered as I read this, and I didn't have it as coherent a thought as the discussion is now leading to. But fraud, right? There's the category of fraud. There's regular fraud. There's half-truth fraud, and there's a category of intentional misrepresentation under California law that involves withholding material facts, right? And I can't remember exactly how it's framed, but presumably if it's common law fraud, we would say the attorney couldn't do it, and we wouldn't care that it was confidential information, right? Even, right? We wouldn't say just because it's, we'd say if it falls within that category of common law fraud, non-disclosure fraud, wouldn't the attorney be forbidden from doing it?
Or you're just using the term unlawfully withholding.
What?
Like, for example, it would be, if it's within the confidentiality and the lawyer's not revealing it because the lawyer is required not to reveal client confidence, then that would be a lawful withholding of information. But an unlawful withholding of information might be something else.
Well, but the fact that information is confidential does not make its withholding lawful if there's an otherwise legal obligation to produce it. Confidential information is everything relating to the representation. So it can't be the case that you get out from under this simply because the information is confidential. That would cover everything.
What if it was just client information, documents about the business, and he didn't disclose a key document that made the case lack merit, that proved the case lacked merit?
In this
Trying to get to
context,
this last sentence, I was thinking about just concealing by itself could be, the word concealing could be lawful protection of client information.
Sure, but that's why.
Right. All I'm saying is for purposes of getting through this last sentence, it's not using the word conceal, like maybe unlawfully concealing or unlawfully withholding. In other words, doing something that is actually prohibited by law somewhere, in some way. Might be rules, professional rules, or it might be discovery rules, it might be something else. But so as long as we capture that pejorative, that's all I'm suggesting might save that sentence.
Well, I think the second part where it says conceal information, it's telling you it's information that's required to have been disclosed.
Right, that's the
So
assumption.
that's the,
I think the issue is that it's the active verb connecting the lawyer to the concealing.
I agree.
If we make it passive tense, we're good.
yeah, I think to me the essence of it is this. If there was information that was required to have been disclosed and it wasn't, you can't settle the case. You either need to take corrective steps or whatever, regardless of the reason, right? And concealment is the wrong word there.
Oh, I see.
So I think if we just say, the merits of what happened there? Okay, the merits of the client's position, or information bearing on the merits that was required to have been disclosed to the opposing party has not been disclosed, or was not disclosed.
So we just take out
They
conceal.
don't like conceal.
Yeah, if we
Right.
take out conceal and we just say, or information bearing on the merits. Yeah, bearing, that was required to have been disclosed to the opposing party has not been disclosed, or was not disclosed?
Let's fix that problem.
Can't we just say it had to be disclosed?
Yes.
Yes. Bearing on the merits that had to be disclosed to the opposing party has not been disclosed. Doesn't have to have has not been disclosed.
It does.
Yeah. Okay.
It's an interesting, I think that's a good fix.
Yeah.
I wonder if we should put a,
Right.
it's a long sentence, I wonder if we should say such reasons as we include Southern Plain, period. However,
If
However, the
during
attorney,
the settlement. I was just thinking.
however, the attorney may not make false statements to the opposing party about the merits of the,
However, during the settlement process, the
or
attorney.
during the settlement, yeah.
still gonna have
May
argument at the
not.
end. That's fine.
Opposing party,
May not make false statements to the or, oh, yeah.
Exactly.
Let's go back.
I don't know, maybe it was better before we started changing this. See, it doesn't work as well.
Base it on information.
I think,
So I think the
How
one
about-
there was that if it's material information, the other side was entitled to know it.
right, right.
And so,
That's a cloud.
What about if it's the attorney can't settle it if they know that the information wasn't disclosed, right? It should have been disclosed.
Right.
So, did you say that earlier?
Yeah.
Sorry that I'm just coming around to it.
No.
but that's fine, so, right, so
The
maybe,
attorney make false statements or no, unless the attorney,
or know that information that had to be, bearing on the merits, that had to be disclosed was not disclosed.
but I don't mind your however, idea. Let me see if we can see what's on it. However, during the settlement process, the attorney may not make false statements to the opposing party about the merits of the client's case,
period.
nor may attorney settle if attorney knows information or knows what the law. Yeah. Okay, so let's try, such reasonable steps may include settlement claim, period. However, attorney may not, and then take out provided that. So just take that out for a sec. May not during the settlement process make false statements. So take out the attorney does not. Make false statements to the opposing party about the merits of the client's case. Period.
And then just friendly amendment, just move not, or may not make false statements, but during the settlement process as the last clause.
Nor may
Last sentence, nor may the attorney.
attorney settle if the attorney knows. And then the rest of
Or not disclosed to the opposing party.
be disclosed was concealed.
Yeah, that's fine. No, don't take that whole thing out.
Yeah.
You want to take it had not been disclosed and replace it with was concealed?
Which had to be disclosed was concealed.
Well, but I don't know, concealed is a little more sort
Okay,
of.
okay, which had to be, okay. One made the attorney settle if the attorney knows that information bearing on the merits which had to be disclosed to the party, opposing party, was not disclosed.
What is it again? Had to be.
Now we need to comment after.
There you go.
So,
It's you had to be, is not, and that's not what was legally required to be.
That's what we need.
That's what we need.
Yeah. You think you should say that
One
instead?
made the attorney settle if the attorney knows the information bearing on the merits.
I think it's fine to leave it as had if we say was legally required.
they're related, at line 97, it reads, thus continued employment of an attorney who knows a case is not legal or just will violate the State Bar Act. And then similarly at 105, thus attorneys continued employment. I struggled with how that's written, so it's just a wordsmithing issue, but would propose at 97 that it read, thus continued agreement to employment by an attorney who knows a case is not legal or just will violate the State Bar Act. And similarly at 105, thus attorneys' continued agreement to employment is prohibited by the Code 68.
Well, doesn't continued employment track the language of the rule exactly? I don't totally understand what agreement to employment means.
Well, because it's the attorney's, I mean, in an employment circumstance, there's element of reciprocity. I mean, the client has to continue to agree to employ you, and you have to continue to agree to be employed. And I just, as it's written, I'm struggling. And if that's from 6068C, then I'll withdraw. I didn't actually check that.
Let's make sure.
Actually, what we're trying to capture is representation. I mean, that's kind of
Right.
Yeah, it might come from 3-700. I thought.
It's,
I thought it says attorney may not.
See, there it is, 3200 is continued employment.
Yeah.
By 3200.
Pretty else, a member shall not seek, accept, or continue employment.
No, it's not 60.
Yeah, it's 3-200. Prohibits a lawyer from seeking, accepting, or continuing employment. So here we're in a continued employment because at the time.
Yeah, but Eric's right that, I mean, the reason it says that in the rule is because the rule's trying to just not use too many words. You seek employment, you accept employment, you don't really continue employment. You continue to just represent, right?
Well, I think what it's, I think what the notion is that if at any time, even after you're retained,
Yeah.
these circumstances exist, you have to do something.
I
So,
agree.
so you can't keep going once you find this out, even if at the time you accepted, these conditions
Yeah,
weren't present.
which is just the way that Rule 11 works, for example, or
Exactly.
malicious prosecution works, you know. You
And
can
conflicts
work.
work.
As you move through time, those obligations can kick in, and then you're not allowed to go further.
But it isn't odd, I mean, if you look at these sentences, they are odd. Just because, I mean, continued employment of an attorney, I mean, who's acting there? It's not the
Yeah.
client.
Right, and if you read 3.200, it's a member shall not. So it's written in terms of the member's obligation. And that's why I think it's, just for clarity's sake, it's worthwhile considering adding that the attorney is agreeing to continued employment as opposed to the client merely allowing continued employment.
So how about this? Because I don't love interjecting a new word that's not present, but what if we did, thus the attorney's continued employment? Does that fix your issue?
I think that's fine.
That's what it says. That's the original.
Thus attorney's
Thus, attorneys continued employment is prohibited.
Yeah.
Oh, wait, but no, wait, it doesn't work.
But in 97, that's not what it
Wait a
says.
minute. No, it's not gonna work. An attorney who knows, yeah. It's not gonna work to say attorney's
Oh,
continued.
continued employment. No, once the lawyer, attorney knows the case, right?
Yeah.
Yeah.
Attorney's continued employment where attorney or
Well,
if.
in a case, the attorney knows it's not legal or just. Take out by.
You could say continuing to represent a client in a manner where the lawyer knows it's not legal or just.
He's trying to keep the continued employment.
But you want to keep that
I
phrase.
yeah, I mean, I
So,
like to,
the continued employment, take out by an attorney.
In a case,
In
the
a
attorney
case,
knows it's
yeah.
not legal or just, will violate the state bar.
mhm. In case the attorney knows. That would be, hold on, little a. This is a little a, attorney's discussion. Yeah, thus attorneys. Yeah, and then where below there, Eric?
It's
Next paragraph, second sentence.
it was 105 in the red line. It's, yeah, it's the thus.
Continued. I'm okay with it there,
I
aren't
think
you?
it's fine.
Yeah.
Have to take out
It's
by
the
business
active
professional
person is attorney.
Correct?
What?
Is it saying just look if I delete that reference since that reference is wrong?
It's not
Well,
wrong.
it's not wrong.
Oh,
No, it's not wrong.
oh, it's the second part, that's 3200B, never mind.
Are you okay with that? Does
Yeah.
that address your?
Yeah, that does, thank you.
Anything else?
Anything else? Anyone else?
I think the last line of the conclusion is just gonna have to track what the changes that were made to the end of the digest, because there's the language about wrongful concealment. I don't know, people still.
Do that rather than. Yeah, let me see why.
Does it capture?
Actually, I think there it's okay.
Okay.
Yeah, but it's a good point, but I think there, because there's more elucidation of the whole idea, I think it seems okay.
I have a question for you.
our discussion of Kirsch, we say that the court rejected the client's claim against the lawyer, right? But held, do you really think it's right to characterize that as a holding? I mean, I think, I don't know, maybe, again, it's really technical, but we'll hear from Lapton if we do it wrong. I mean, I think a holding is only the result of the case, so I think it's more like behind. Sure.
Where?
It was 144, somewhere around 144.
Yeah, I think it's fine. I mean, I do actually think it probably was the holding in the case.
You do?
Because it's the basis for which they find the client's claim is, because the client's claim was based on the fact that the attorney took too long to withdraw. And so the court, oh no, I'm sorry. that the attorney delayed so long that it was right before trial that they withdrew. And that was among the bases for the client's claim, was that the attorney had waited and therefore prejudiced the client, because by the time they withdrew, it was very close to trial. And so the court says, no client, no wrong, because in fact, the attorney should have waited, because, you know, immediate withdrawal would have been inappropriate. So it is more of the, it is, I think, more of the foundation for the conclusion. So yeah, we're probably okay with it. Yeah, I'm glad you pointed that out, because I hadn't remembered. What?
Actually, I have one typo.
Sure.
Unless we already got this, but on 183, actually 182, this sentence says, this conclusion is consistent with an attorney's duty of competence and do we get that? Okay, I'm sorry. I'm losing it.
I'm with you.
Okay. All right, any other comments? Nits or otherwise?
Ready for a motion?
Anybody want to make a motion?
Yeah, I'll move we push this puppy along to the next stage. I'm not sure. Recommend adoption.
I second that.
Puppies and
It's quite the specific motion.
Remember, this is being webcast.
Reading that as a motion to approve this opinion, put it out for public comment for how many days would it be?
It's 90 days.
90 days? That's the motion? And there's a second for the motion?
Mm-hmm. Okay, ready? Andrew Dilworth?
Yes.
Amy Bomsey?
Yes.
Kendra Basner?
Yes.
Stephen Bundy?
Yes.
Eric Deitz?
Yes.
Justin Fields?
Yes.
Matthew Hodel? Joel Osmond? Marlo Richardson? Gina Roche?
Yes.
Teresa Schmidt?
Yes.
Ujjwala Singh? Richard Solomon?
Yes.
Stephen Sparta? Marsha Whitney? Thank you.
Good job, everyone.
One more left, eh?
All right, it's
Awesome.
3:25.
3 years.
Do people want their 3:15 break, or should we just?
Stretch break.
Yeah, let's at least take a 5-minute stretch.
You have to do a symposium.
Oh, yeah.
And we can
5 minutes.
Oh, yeah, yeah. Come on.
So come
for
back,
sure.
everybody.
All right, 10-minute break.
10-minute break, that sounds good.
Thank you.
So if we don't get to stolen.
I was kind of
Which I know you're
I got
not.
Well, it's interesting.
Because I
It's
know
all-
everyone's
Yeah.
Is it different?
It's highlighted.
Thank you.
It's an H psychological burden or under concern or
Something new?
it's just
All right, great job. Okay, let's go back Back on mic, I guess. 3:40. So we're going to spend a little bit of time briefly covering some issues for the ethics symposium, and then we'll move to another opinion. So the symposium's coming up on Friday, April the 6th. We talked about topics before. What we need to do today is number one, Steve's going to give us a little bit of feedback on what he learned about codex. And then we need to talk about what the panels are going to be, who the moderators are, and a little bit about timing in terms of moving forward with planning for the symposium. So, should we start with codex?
Sure. So I spoke, or was in communication with, Mark Lemley, who teaches at Stanford, and Oliver Goodenough, who teaches at University of Vermont, who are two of the codex principals. And I had a short communication with Mark, and then a longer communication with Oliver, long talk with Oliver, and read a bunch of stuff about codex. And bottom line is, codex is really interesting, but I'm not sure I'm pretty sure it's not right for the symposium. The core of codex is really artificial intelligence. It's basically about how you can mimic legal reasoning in different ways, or legal process thinking using computers, or how the law is a computer. It's like computational law is one of the ways they talk about. One of the so without going into a lot of detail, there are a lot of applications, right? Some of them are, and there are a lot about, some of them are sort of, how do you make lawyers more competent? And others are about how do you replace lawyers? Right? And access to justice kinds of issues. So the ethics issues are kind of, they're unauthorized practice of law issues, they're competence issues, there are sharing fees with non-lawyers issues, and so forth and so on. It comes back, though, to the fact that you wouldn't probably want to do something on artificial intelligence alone. You'd want to make it part of a broader thing on access. And we did a very successful panel on access just a few years ago with John Steele gave one of the best talks I've ever heard at one of these events. And then there were a number of other good participants. We had, I can't remember which one of the LegalZoom people and so forth. So unless we were going to go back to that route and do that, I don't think codex is a way to go. It's not really a straight ethics play that generates enough stuff. So that's number one. And I'm open to questions, but it just didn't seem to look too promising. None of the people involved are ethics people. They're all about artificial intelligence or access to justice types.
Well, I do, from my perspective, I agree that it probably doesn't make sense to go back and revisit something that we did recently. I mean, I realize it's a different angle on it, but I mean, if it doesn't support itself in and of itself, and it's going back to something.
But I don't think the issues have changed.
Yeah.
That's another piece. I don't think there's a new hook here.
So I think, I mean, certainly, any questions anybody has, let's field them to Steve, but assuming it's not going to be a good topic, then I guess the next question becomes, what should the other panel topic be? But before we get to that, does anybody have additional comments or questions for Steve about the codex issue? I mean, I'm satisfied, based on what you said and your assessment of it, to say it probably doesn't make sense to do that as a panel, it seems to me.
Certainly not as a central focus, and not in a broader framework unless you want to repeat what you did a few years ago.
So if we were not to do that, and, you know, we voted on a series of panel topics and we tallied the votes, we might have had some ties.
Yeah, these three, in-house counsel versus outside counsel, attorney competency and positional conflicts were the next runners up, and they all had 4 votes each.
And so, yeah, just stepping back for 1 second, for those of you that are newer members, so, and we may have said this at the last meeting, but typically what we do is we offer the opportunity to moderate a panel to the people that are the more senior members of the committee. And outside of leadership usually does a panel. And this year that is Steve and Joel and Ujvala. So they're not obligated to do it, but we would offer to have them as moderators. And we've offered to do that, and each one of them has expressed interest in doing that. So we have the moderators. The question becomes, what are the panels? And Ujvala and Joel are not here today, but Joel has expressed interest in the 8.4.1, or a preference in moderating that panel. Ujvala has indicated a preference in moderating the joint defense panel. And so the ethics update typically is done by leadership. I think that makes sense, and leadership this year is inclined to do that. So then the question becomes, for the last panel that Steve, if you want to moderate, you're certainly welcome to moderate. We encourage you to. What should the topic be? And so that gets us to our list here.
Well, I want to make a pitch for a version of something that would mix some things up, right? Well, but I think one piece would be, you could think of a lot of the panelists centering on opinion 12005, which we just had a very compelling discussion about. And you could imagine running it in different directions, right? That's about the ethics of consulting with respect to your ethical obligations. It would be really interesting to run the front end, which is when do you have a duty of disclosure, right? And then you come to the question, as we have in the opinion, of what you can say. There's the question of what are your ethical obligations in consulting. There's the question of privilege, right? And there's the interesting back-end question, right? Which is which we've avoided in our opinion, but which would be really interesting to talk about, what is the right, when does the conflict arise, what kinds of disclosures and waivers are required. And I also think it might be interesting if we want to put somebody who's an insurance person on the panel, because I think a lot of ethics lawyers think of this question apart from insurance, and in fact, you cannot make a move on this kind of question if you're without knowing your terms of your insurance policy and doing appropriate disclosures to them and getting their permission to say what you want to say. And so that would be the sort of range. And I even have some ideas about who should be on the panel, and one obvious person is Mary, which would be a lot of fun. And then could work from there, maybe an insurance person, maybe a plaintiff side person, thoughtful plaintiff side person, and that could be really, what?
Is it thoughtful? What do you mean by that?
No.
Aren't they all?
Oh, yeah. Anyway, that's the range of, I think it would be interesting for people. And useful, and a nice way of showcasing the 12005 opinion and honoring Mary's work too. So those are my thoughts.
Well, I'm trying. We had this previous in-house versus outside, which I guess
that's related to this.
Was it different than this, or related?
No, I think what I've done is I've tried to fold that in, or use that as a vehicle for thinking about something a little more comprehensive and interesting.
Yeah.
I'll just say personally, I'm not interested in attorney competency, and I'm not sure that positional conflicts, which I think are really interesting, is enough for a whole big long panel. I think that they're really interesting, but I'm not sure that you.
I would also say on the competency side, I mean, outside of COPRAC, there's been a lot of that at some of the types of conferences this audience may have gone to. That's been a topic that's made the rounds in the last year or two a lot. So to me, it's a little bit redundant. Well, I like your idea, actually, and I like the idea of someone like Mary being on the panel, and in some ways I like the idea that, we have this opinion that's coming out, that it dovetails with to some extent. I know there were some concerns maybe about, things devolving into too much of, one camp versus another on in-house or outside counsel, but I don't hear what you're saying as being, structured in a way that is particularly going to facilitate that. I think you're talking about something much broader and different, quite frankly.
Think about something that's of interest to every lawyer.
Yeah, so
and every lawyer has an interest in having the rules be right.
I like it personally. I don't know how other people feel about it, but I don't have any problem with that. It sounds like a good panel to me. And you want to do it. Makes it even better. You're interested.
Yeah.
Makes it even better.
It's fun.
So let's do that. I don't hear anybody raising any strong objection to that, so let's have that be our other panel. And as I said,
I'll send you some better language rather than try and dictate something or work something up now. I'll just send you a couple of sentences to 3 sentences, and then we can.
What else do we need to cover on this? But we'll want to set up. We need to start thinking, and Steve already alluded to thinking about certain panelists, but the moderators will need to start thinking about panelists, for each of the panels. And we should all do that and provide suggestions, obviously. I mean, just because we're not moderating it, we may have ideas of people that would be good panelists. For budgetary reasons, we're in Northern California this year, so to the extent there are people geographically that are closer or may not be as expensive in terms of getting them here, wherever they're located, for whatever reason that may be the case. We'll try to be sensitive to that, but I mean, we want to have good panelists, so I guess the message is just start thinking about who good panelists might be, and if you're not a moderator, share your ideas about potential panelists with the moderators. And then I think, we don't have to do this now, but probably we can do it offline, so to speak, but set up a call in the not too distant future with just the moderators to talk in more detail about potential panelists and just timing it. Any other sort of immediate timing issues that we need to discuss with respect to this? There is a chart here I know you've given us that has a list of different deadlines.
So yeah, no immediate deadlines for the larger group. The moderators, next big step for the moderators and leadership is to consider titles and descriptions for each panel, which can certainly be done via the phone call. We should, all of the moderators have volunteered, which we greatly appreciate, and so we can schedule a phone call, if not next week, certainly the week after, so within the next 2 weeks. And so in terms of deadlines, those in the room who are not a moderator, if you have potential panelists, specific people in mind, please email them over the weekend to either staff. Let's just give it to staff, and staff can get them out to the panel, to the moderators, so that they would have those suggestions when they consider it on the phone call. On the phone call, they won't be determined, but the larger group of moderators typically brainstorm together to come up with some panelists, and so that's a good idea. So
there might be some overlap too. It's worth knowing who the other moderators are thinking about. So.
Exactly.
Just out of curiosity, and maybe on this list of deadlines, but when typically would we start to be actually marketing, like formally marketing the symposium?
So we just sent out an email earlier this week to our interested individuals email group. And then we'll start, you'll see, there's, we send notification via the Cal Bar Journal and the State Bar website. That'll begin in early February. And the highlighted portions of the schedule are really what the deadlines are for the committee members. The rest are a lot of internal staff deadlines.
We already have kind of saved the date stuff.
Just going to save the date, with not much description because we haven't come up with titles and descriptions, but we have the dates and we have the location, so that's starting to get publicized. And of course, everyone here is encouraged to publicize the event as well.
Right, and as a reminder, everybody knows, but I mean, it's here in San Francisco at the State Bar, and because of certain availability type issues, we're having it on a Friday again. This will be the second time we've done that historically. It's usually been on Saturday, and so we'd really like to try and get, you know, as much attendance as we can, and so anything we can do individually, even informally, as Andrew said, starting now, you know, to drum up interest, you know, please do so.
Just so you guys know, so even if you don't have all your panelists figured out, if you have a description, just having a title and description would even begin to help, because I can go ahead and put that up on the State Bar website. Now, this deadline of February 5th to give us your descriptions and panelist names and all that stuff is so that we can start preparing the brochures that need to be mailed out for registration. But before that happens, I can even just go ahead, and you guys can figure out what order it's going to appear in. Panel title and a brief description, that can go up as soon as I receive just that little information from you guys.
And the 5th's not that far away.
Right.
Period, as far as panelists, and sometimes it takes a while for people to get back to you and all that, so we should get moving on it for sure.
Yeah, and as soon as that goes up on the website, then we can start tweeting it and reminding people. You can send out a tweet every week or every 2 weeks, just saying symposium's coming up, go sign up.
I have a question about the facility and what kind of room is, you know, is it this, and are we just going to put a bunch of chairs, or are there going to be desks and then chairs, or just chairs? Because, yeah.
I don't think a final decision's been made on that, but I expect they'll do a setup what they call classroom style, which is desks, horizontal row all the way to the back. I'm not sure exactly how many seats that can fit along each row, but you know, there'll be a table about where Drew and Amy are sitting, and the moderators and the panelists will be up here, and then we'll get as many rows horizontal similar to that table in the back with just chairs all the way through. The other option is no table. We could probably get some more folding chairs in, but I'm not sure that's as comfortable. But no final decision on the room orientation has been made, but I think those are probably the two options available.
And it'll depend on how many people actually register.
Okay, so it's a room, like, they don't have like a classroom or a nice sort of room the way that we've been using for all these past years. So it's going to be like a flat banquet style thing, and then will we at least have two things like this so that...
Two or one, absolutely.
It stays here. This is now a permanent fixture in this room, I believe.
So
and I think there's even
two
the option...
screens, a front table, and then either a series of tables to the back or a series of chairs is what it says.
And also, I think recently they changed it so that there's actually a monitor they can set up right here so you can actually see your presentation. In the past, you know, we don't usually do it, but I believe that's how the board's been doing it. So it'll be more user-friendly to the presenters. You'll actually be able to see the screen. There's a TV that's slanted at an angle that's right here. That would be set up right here for you.
So not that anybody asked for it, but I personally think that it's a lot to ask someone to sit for 8 hours or something in a chair like this with like whatever materials they have on their lap. So I would personally vote for, you know, the classroom style, so at least you have somewhere to, but that's
my sense too.
They do hold ethics school here, I believe, and some other like MCLE courses where it is set up like a classroom. I don't know what the max capacity is, but I can find out.
I think that's preferable unless there's some kind of capacity issue. Okay. Anything else on the symposium for the moment? Okay. Eric, you look like you had a question.
Just a thought. If the orientation is rows of tables in a classroom setting, I'm wondering if there's any ability to put a dais here so that the presenters are visible from the back. I don't know that we'll be able to see them. Yeah, raise the presenters. Models.
All right, so we'll go back to our opinions now, and let's talk about marijuana, which is 170001. So, just to give a very quick backdrop, because it's been a little while, but you may recall that a couple months back, we took up the issue of whether this would be something to do an opinion on. There were some specific requests that were made to the state bar, interest in having an ethics opinion on this issue. There's obviously already been an LA opinion and a San Francisco Bar Association opinion that deal with the issue. There's been a bunch of opinions outside of California. But the view, at least by some, was that there was still a real desire to hear what the state bar's ethics committee had to say about this particular issue. It's an opinion that we flagged as wanting to move quickly on, and there's been a number of developments recently, quite frankly. I mean, the recreational use has become legal since the last meeting. We had Jeff Sessions indicating that the Cole memo was going to be rescinded, or whatever the appropriate verbiage is. And so what we have not done is really had an opportunity to vet as a group here preliminarily sort of where we're at on this issue. We have a draft here of an outline. The outline is, I would say, is drafted in a way that makes points towards conclusions that are not inconsistent with the conclusions that have already been reached in California by the LA and the San Francisco opinion. That's not to say there are conclusions, or they have to be. In this outline as it exists, I think is a fairly good representation of the types of arguments that have been put out there so far, not only in the California opinions, but in a lot of the opinions from other states as well. And so I think we need to have a discussion to sort of take the temperature of the committee to see how we feel, generally speaking, about this issue, so we know which way to be driving in terms of starting to, really put pen to paper and work on something that's fleshed out beyond an outline. But some of the big concepts that have been dealt with, or the major concepts that have been dealt with in the opinions that exist on this topic, and also in California, are the following. I mean, number one is the issue of advising about compliance with California's marijuana laws. And I'm not going to get into all that. I mean, we all know, that we have the issue here in a very general sense is that the state law authorizes conduct related to marijuana that is not legal under federal law. There's definitely issues about, preemption, but there's a tension. There's a tension between what the state law allows and what the federal law allows with respect to, the same conduct, so to speak. And so one of the obvious issues is, lawyers are not ethically allowed to advise the violation of law. And that's been a central issue that's been looked at these opinions that have dealt with marijuana, both in California and outside. And so if you break that down a little bit, I mean, one question is, just advising a client with respect to compliance with the law. In other words, California allows it, the client comes to you, they're in California, they want to operate in California, they want advice about how to comply with the law in California. and not to overgeneralize, but a lot of the opinions, that seems to be not the hardest question for everybody. A lot of opinions come out saying, well, it's simply advising about the law, that's not going to be advising the violation of the law. But you have this issue of, okay, advising them about compliance. Then you have sort of another step, which is, what if you do more than advise them about compliance, but you're helping them, you're assisting them? Or somehow it's going beyond simply telling them this is what the law is and this or would or wouldn't comply with this regulation, but you're actually helping them. You're assisting them or implementing, like what?
Like drafting a contract for.
Sure, yeah, so, you know, a contract that a marijuana business wants to enter into a contract, you know, for whatever, storage or something like that. So they're not just saying, how do I comply with all the regulatory scheme surrounding cannabis? They're saying, help, you know, provide me with legal services that help me further my business, and my business is the operation of the cannabis company or distribution, et cetera. Then you have sort of another interesting question, and I think the LA opinion dealt with this a little bit and actually decided that there wasn't really any distinction here, but the question is, what if you have someone who is in the industry, so to speak, and they want legal services, and the legal services don't really have anything to do with compliance? It's like the normal type of legal services that you would go to a lawyer for. Can you review this contract? Can you give me employment law advice related to my employees? But they're operating a business that, again, is authorized or permissible under the regulation of California, but maybe not under federal regulation. And again, I think that the LA opinion kind of said, does that make a difference? And they end up concluding, and I'm being very summary here, that it doesn't really matter. They reached the same result regardless. But that's one sort of issue that's been dealt with. And then another issue, and we can talk more about the specific points, but one of the issues that you see repeatedly in the opinions that talk about this outside of California as well is this notion of, is a lawyer that provides services to someone in this industry in California testing or challenging the validity of a law. So in California, under a rule, you can't advise, you know, the violation of a law, but you can engage in conduct, and we'll give you the actual language. Is a member shall not advise the violation of any law, rule, or ruling of a tribunal unless the member believes in good faith that such law, rule, or ruling is invalid. A member may take appropriate steps in good faith to test the validity of any law, rule, or ruling of a tribunal. That concept's been something that's been articulated in a number of the different opinions that are out there. In my view, it's never really run to the ground. It kind of gets thrown out there, but I think it's an interesting one. I'm not sure where it gets us at the end of the day. I will also say, as a predicate to all of this, that if you read the opinions, in my view, they're a little bit of, I mean, if you take the ones that say that it's ethically permissible to do this, the analysis in terms of how do they get there is kind of a bunch of concepts. And mushed isn't exactly the right word, but it's kind of, you get there by taking a lot of different things and kind of balling them together. And at the end of the day, they say, you know, that this is not an ethical violation. And so we have to unbundle those concepts and look at them, I guess. But Richard made the point in the subcommittee group, and I sort of agree, that one thing we should focus on is once we decide where we're headed, trying to be sort of as precise as possible about the reasoning and why we reach the conclusion we reach, because it does sort of feel like some of these opinions are kind of getting to the conclusion, they want to get to the conclusion, and you read through the analysis and it's just kind of pulling a bunch of things and sticking them together and saying, you know, here's the result. So anyway, that's a very long-winded introduction, but again, I mean, I want to take the temperature of the group. I mean, what do people do? We have not had this discussion. So, I mean, the most basic level, you know, I want to get a sense of whether people think they're inclined to think that this is a violation of, advising the violation of law, or that it's not. I mean, it's a very unusual situation. I mean, you clearly have one body, the state, saying that this is permissible, and your advice would be related to complying or carrying out conduct in that state, you know, under that regulatory scheme, at the same time that you have another body saying that this exact same conduct is not permissible. And so, you know, is helping someone comply under the scheme that permits it automatically, because of this other system that is there that says that it's not lawful, is that advising the violation of law?
Well, there's a threshold question, which is whether, in light of comment 6 to proposed rule 1.2.1, as you pointed out earlier, that if this is adopted, this comment sanctions the representation.
You want to read the comment for everybody?
Well, paragraph B to the rule says, for purposes of this rule, reasonable, oh, sorry, wrong page. Notwithstanding, well, paragraph A says a lawyer shall not counsel a client to engage, assist in, which is criminal, fraudulent, in violation of any law, rule, etc. Notwithstanding paragraph A, a lawyer may discuss the legal consequences of any proposed course of action with the client, and counsel or assist the client to make a good faith effort to determine the validity, scope, meaning, or application of a law, rule, or ruling. And comment 6, paragraph B permits a lawyer to advise a client regarding the validity, scope, and meaning of California law that might conflict with federal or tribal law. And despite such a conflict, to assist a client in conduct that the lawyer reasonably believes is permitted by California statutes. Well, California statutes is relevant here. If California law conflicts with federal or tribal law, the lawyer should also advise the client regarding related federal or tribal law and policy. So it follows what Colorado did. The Colorado State Bar ruled that it was unethical, and there was a petition made. The Colorado Supreme Court amended their substantive ethics rule to carve out this exception where there's a conflict.
So I don't know all the details, but my general understanding, and take it with a grain of salt, is that there was maybe a pitch at the RRC to be specific about the marijuana issue. And I think that the decision, for whatever reasons, and I'm not going to pretend to articulate it, was not to do that, but to do the comment. And I guess your point is, if this is adopted, why do we need the opinion? Is that what you're...
That's the question.
Okay.
Is it wise to wait, or do we want to go ahead and go through the opinion? I'm inclined to go ahead and do the opinion. That seems to me we should address that in that consensus.
Conversely, if that comment is not approved, it raises a question about whether we can write it.
Then do you still want to do the opinion, knowing that is that what you think?
Good point.
I'm just raising a question. I think it would cut against being able to write an opinion.
Yeah.
So, Drew started this conversation off by noting there have been some recent developments since the last meeting, which is true. And just to reiterate, there is a lot of interest in this committee developing an opinion on this topic. So I strongly encourage you guys to undertake the difficult task that it is to draft an opinion. Certainly comment 6 could and should be referenced. Whether it's adopted or not, in my view, does not answer the question one way or the other. The reason why it doesn't answer it if it is adopted is because it's not quite as specific. Certainly easy to infer from the language, but does not address marijuana specifically, and it would be a great example of something that I believe that comment is attempting to achieve, and so the opinion could flesh that out and reach those conclusions. If the comment were not to be adopted, I don't think that precludes analysis on this question. Of course, it removes a strong pillar for which one could rely. But as of earlier this month, January 1st, an exception to the exception in the evidence code was adopted. That was Assembly Bill 1159, which added a subparagraph B to Evidence Code 956. And the new subparagraph 956 is there's no privilege under this article if the lawyer seeks to help someone commit crime or fraud. And subparagraph B, which is now operative, says this exception to the privilege granted by this article shall not apply to legal services rendered in compliance with state and local laws on medicinal cannabis or adult use cannabis, and confidential communications provided for the purpose of rendering those services are confidential communications between client and lawyer, as defined in Section 952, provided the lawyer also advises the client on conflicts with respect to federal law. Of course, that's narrow with respect to the evidentiary code. We all know these discussions because we have them in many of our opinions. But along with common sense,
how do you defend your conduct without waiving the privilege? Exactly. So
no, I'm not.
No, I'm just here. Just the way it's phrased. It's a little curious.
Yeah, not trying to say it answers the question, but it is something that could be referenced, cited, and noted in terms of the policy that's reflection of policy in the state. So certainly we have things to discuss and analyze which were not touched upon in the local county bar opinions or these other state bar opinions, and I think there is a great interest and could be very productive, for the committee to analyze and publish an opinion on the topic.
Well, I take Richard's point. I don't know that, I would still like personally to get some sense of where people are at on this issue, assuming we move forward with doing the opinion.
So I have a comment, which is that I don't know where I am on this. Like, I don't have an independent feeling. I think we need to look at where the authorities take us and what we think is supportable and what isn't. To me, it's like, you might be putting the cart before the horse a little bit to say, like, what do you think the conclusion should be before we really had a chance to. But I understand what you're saying.
Fair.
Is anyone like violently opposed to some?
And I'm not trying to get to the conclusion, I guess. And maybe I'm being unfair in assumptions, but I'm assuming that people have some familiarity with some of the issues that are. The issues are not that we might not find something that's different, but if you look at the opinions, and there's quite a few of them now, the issues tend to be the same, and they're kind of reiterated throughout the opinions, and there isn't a lot of difference in the issues themselves, but there is very stark contrast between, there's a camp that's end up saying, that we think that this is permissible, and there's another camp that says we don't. And the camp that says we don't seems to have I don't know if tautological is kind of the right word, but they have a very kind of mechanistic, the analysis, not to oversimplify it, is it's not permissible under federal law, and so if you're telling your client or advising or assisting them in doing something that violates the federal law, that is advising the violation of law.
So that's
therefore
where,
you can't do it, and of course you couldn't do it.
I don't understand. So I want to ask you about, are those opinions are wrong? I haven't read them all. Are they basing it on our version of 3.210? Because 3-210 to me does not say that.
No.
So, and I don't think we have a California law that just says you can't advise on violation of the law. 3-210 is very limited to the litigation context and asserting a claim or a defense or bringing a claim, right?
Well,
So is there another?
Well, first of all, the opinions that say that are not the California, I mean, there's two California opinions, that's San Francisco and LA, and they both conclude that it is ethical, that it's ethically permissible for a lawyer to provide at least certain types of advice and do certain things. The opinions that are in the camp of saying it's not ethically permissible are all outside of California, so none of them deal with,
Right.
with 3-210.
But are they basing it on a version of 3-210? Or what is the model rule that, if we know? And I raise it because I think we might be in a situation where we don't have California authority, so we need to look at the model rule. So
it's 1.2D in the outline here. It's the second page, very bottom. 1.2D, which says a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. And they say, and again, I may be oversimplifying, but those opinions tend to say it's criminal under federal law. The lawyer knows that. You can't counsel or assist a client in carrying out conduct that you know is criminal conduct under federal law.
And Suzanne, the tying in California, absent a specific rule as you identified, probably be the Business and Professions Code 6068A, which is the broad general proposition that is a duty of a lawyer to support the Constitution and laws of the United States and of the state.
Well, and B, I mean, if you look at that same page, I mean, in the California opinions, what they look at principally are 3-210, 6068A, as Andrew mentioned, 6068B, which is maintaining respect due to the courts of justice, 6106 on moral turpitude. Those are the things that the California opinion in terms of authority has tended to focus on. And again, the two California opinions, they look at those, you know, each one to a certain degree, but they reach the conclusion that it doesn't violate any of those. The couple out of state that say it's a violation, they're, I believe, focused principally on 1.2D.
So that's what concerns me a little bit, because I mean, I look at these authorities and I don't think that they're particularly applicable. 6068A, I mean, I think you're really stretching it, that you're not supporting the Constitution of the United States by giving someone access to legal advice. But my concern is that if we don't find California law applicable, we're in an area where normally if we don't have California law, we do go to the model rules. Well, we don't have to, but that's what we normally do. And if we don't really want to look at them, if we interpret that language of the model rule to say it's counseling the violation of the law, that could be a problem. I would love to find something that talks about the ability to challenge the validity of a law.
Well, just to be clear, the out of California opinions that say it's not permissible is a minority. The majority of opinions out there right now, all the California opinions, which is 2, say it's okay. The majority collectively of the opinions that exist say it's okay. But there is a camp of opinions out there outside of California that says it's not okay. There are differences between 3-210 and 1.2D, and actually the LA opinion does a pretty good job about highlighting some of those. For example, our rule 3-210 says a member shall not advise the violation of any law, rule, or ruling of tribunal, et cetera, et cetera. It doesn't say anything about assisting. The language is not there. If you look at 1.2D, it says the lawyer shall not counsel a client to engage or assist a client in conduct the lawyer knows is criminal or fraudulent. So, I mean, there are some differences. Another thing that's in 3-210 that is different is it says a member shall not advise the violation of any law, rule, or ruling. Is that, I mean, in a very broad sense, any means arguably federal as well as state. 1.2D doesn't have that. It just says you can't counsel, clients engage, or assist a client in conduct you know is criminal or fraudulent. But look, I mean,
What about 610? Yeah, I mean,
I was
uh,
thinking a different.
how is assisting the commission of a federal crime, you might ask, not an act involving moral turpitude, disruption, or you know, what would happen if somebody came to the state bar seeking discipline for moral turpitude for a conviction for violation of federal law? Would there be any argument that it wasn't? And this is a question I'm asking as devil's advocate. Was there any way that would not be a crime, an act involving moral turpitude?
if at the same time the state law authorized the very same conduct?
But they were convicted under federal law?
They were indicted and convicted, and that conviction was forwarded to the state bar for action. Could the state bar declare that was not moral turpitude without having that holding itself preempted by federal law as discriminatory?
If the conduct was lawful under California law?
Yeah. Yeah, because we know California law is preempted. There's lots of authority that says that California law here is preempted, right? In the sense that it would not be a defense to a federal prosecution.
Well, to a federal prosecution, but you're talking about a...
Yeah, no, I'm working it around.
Yeah, no,
I'm saying that if a federal criminal conviction for this this is the embarrassment for the position. It's the difficulty in the position, right? Is that this conduct has been held to be preempted, right? And is not a defense to a federal charge. So the question is, why isn't then this, if 6106 doesn't encompass, right, assisting in a federal crime, how can it's itself preempted, right? That would be the argument. I'm saying that I think is the nub of the problem. I don't think we can get out of this by saying California has no rule that speaks to this kind of question, to assisting a federal crime. No, California has to have a rule that speaks to assisting a federal crime.
I was looking at 3-200, not 3-210.
What?
So I was looking at the wrong rule when I said that. I was saying 3-200 is limited to a tribunal situation.
Yeah.
3-210 is not.
Right, yeah, I wasn't sure.
So that was, I may have gotten us going down that road.
Okay.
Because I was looking at the.
But
3-210 is.
But wait, so Steve, you're saying a lawyer is convicted of assisting the commission of federal crime.
A federal felony.
Right, and then that's forwarded to the state bar.
Yep.
On the grounds that it's moral turpitude.
Yep.
And the state bar finds that it's not, because they find, no, the actions were assisting in what's legal in California.
Mm-hmm.
And then you're saying somehow the state bar's ruling is preempted? That's where you lose.
It would be a concern, I think, if that ruling didn't represent a kind of discrimination against the federal law, right? Or a refusal to honor the federal law by setting it on a lower basis than state law. It may be...
The question is, can the federal government come in and sue the California government for having the law it has? Right? Is California not allowed to have this law?
Is California not allowed to have this law?
Yeah, can the
Well,
federal
can Roy
government
Moore the hard question is, can Roy Moore put the 10 Commandments on or ignore a mandate of the Supreme Court, right? There is a question about what's your obligation to honor settled law, right? And if settled law is that California law does not make the conduct legal under federal law, that's the position, I think. It's not a formalistic position, right? It's it's got a moral and if you will, policy basis. I think if what we need, I think the reason the opinions that Drew has been citing read in a slightly jumbled way, right, is because that's not actually an easy position. It's not necessarily an easy position to reach strictly on logical grounds. And it needs to be, you need to say something about why this situation is different. Right? You need to say something, and I think it has to do with the widespread, the degree to which this is reflected in state policy, the degree to which it's reflected in the policies of lots of other states, and the degree to which the federal policy, although reflected in a criminal statute, is not fully enforced. And that those are the factors that bear. We would not want to give this opinion as a general matter with respect to conduct that's criminal under federal law, even if state law authorized it.
Well, there's no other circumstance that exists like that.
What?
I mean, there's no, you're saying, well, we need to be specific to this particular circumstance, but this is the only circumstance that exists like this, where there's this conduct.
Well, that may be part of the answer.
To me, what drives my
But it isn't the only situation you can imagine. Remember that the South had on the books a huge number of laws authorizing or requiring racial segregation. Right? Now, following Brown versus Board of Education, or even following and recognizing some of the ways that federal criminal statutes were extended to, to punish deliberate civil rights violations and make them criminally. Would we want to say that if that violation is lawful under Alabama law, that an Alabama lawyer can help his client engage in criminal forms of civil rights violations?
But the question is, let's focus on the ethics question.
I am focusing on the ethics
Well,
question.
not when you say that, if you pose it strictly as whether a federal prosecution, for example, for possession of drugs or for engaging in unlawful discrimination under the 13th Amendment or the 14th Amendment or the Civil Rights Act, that's a substantive criminal law issue. And yes, federal law clearly preempts and would apply. So a lawyer who's assisting a marijuana business, as well as the principals, could certainly be criminally prosecuted for engaging in a violation of federal law. But the question of whether the lawyer is acting unethically is a separate issue.
It is, but you have to think about this question in terms not only of laws that have appeal, right, and that are widely, that are represent what we think is the wave of the future, but also with respect to laws that might sit in a different status. You have to, I don't think, because we don't want, I don't think, to endorse the proposition that just because conduct is lawful under state law, that a lawyer can advise or assist in a crime, a federal crime. We don't want to endorse that generally, and maybe that's wrong. But maybe that's my instinct: is we need to figure out a way. We need to be forthright and direct, but we need to figure out a way to explain that that's not what we're saying, and it's not always true that you can.
So two comments in that regard. One, and I'm not saying this is satisfying, but just to your point, to the extent in looking at some of these other opinions that they've touched on that issue, what they tend to say, and I don't think it is what you're saying you would want, but I mean they're kind of gloss on that, if you will, when they get, is to sort of say something to the effect of discipline is, it's all controlled and within the realm of the state. That the issue of, what you may be disciplined for and the rules of professional conduct and so forth are all state regulated. That, the federal authority doesn't have any control over that whatsoever.
So they try to, I'm not saying it's satisfying, but to that issue, to the extent they try to deal with it in some of these opinions that are out there, that's the corner they like to go to, so to speak.
And that might be right for 6106. It might not work so well for the, whatever the equivalent of 1.2D is.
Okay.
Right? I mean, that's at least the thing that's where I think we need to work as a committee to be persuaded that we have a line that doesn't, I don't think, that suggests something narrower.
Well, and here, in I guess my second comment to that is, again, one of the other issues that you see come up quite frequently in the opinions is this notion of challenging or testing the law. And I don't know if that gets to what you're talking about either.
I'm not sure it does.
I think it does.
I'd like to see what the preemption case law is like.
I think it does.
Wait,
yeah.
I'm sorry, Stephen, you say, I'm not sure it does.
I think I need the question, there's the question of what the preemption law says.
Mm-hmm.
But
Right,
you could be challenging the preemption law.
Yeah, you could if you had a non-frivolous basis for doing so.
Right, and your non-frivolous basis might be, I am a states' rights
I'm
believer.
just throwing out.
That's like non-payment of taxes, people.
Well, no. Well, look,
There's a lot. I mean, I think you got to have a real legal argument, not just there's a states' rights argument.
Even if that's true, I'd like to see how far that gets you, because if your job is to negotiate a contract between the storage place and the marijuana producer, you're not challenging the state law. I mean, I think these exceptions are when you are actively challenging, like saying to a court, I want a debt relief, I'm suing for declaratory relief that I can do this.
Or you're advising a civil disobedient, right, who's prepared to run the risk of prosecution.
Right. I feel like that's a very narrow exception, and we can't drive the truck of this opinion through it.
I think it's hard to get away from the first sentence of 3-210. But I guess you'd have to say that doing a contract is not advising a violation of law either.
Right. I think
Doing
the
a
fact
contract for storage of cannabis is not advising the violation of the law.
We're really helped by the fact that we don't have the assist language that 1.2D does, the assist crime.
But I find the discussion comment strange on that point. Where the second sentence, Rule 3-210 is intended to apply not only to the prospective conduct of the client, but also to the interaction between the member and client, and to the specific legal service sought by the client from the member. And then they use as an example, therefore, the attorney can't try to negotiate the return of stolen property in exchange for the owner's agreement. So that's more of an assistance. So it's kind of strange how, I'm not saying that discussion point is a model of clarity, but it does seem to interject this idea that the services the attorney is providing may also relate to this illegality concept, this assistance idea.
Well, on the challenging the law, as I said, that's a concept that gets thrown into a lot of these opinions. None of them run it down. And so we were discussing this off the record earlier. What does that really mean, and what's the scope? Which is what Amy's getting at. I mean, is a challenge a legal challenge, or does it mean conduct? And if so, has it got to be conduct like the willing client, who's going to get prosecuted and now have standing to defend themselves, or does it mean simply that the guy who's helping the person out there with the marijuana business, and that probably, I don't know the answer to that. I guess we do some research around what does that really mean to challenge, how much of a tangible kind of action or activity do you have to do to qualify as challenging, so to speak. But I'm not sure it's really, I don't know what the answer to that question is in terms of the scope, and we can look at that, but it may not get us to where you're talking about, Steve, anyway, even assuming it was a broad scope, that just the conduct, even outside of a court or setting up a situation to challenge.
Well, I actually think we should explore trying to write the opinion that would be consistent with the results reached in San Francisco and Los Angeles. I think we should push to do that. We can't know without fully evaluating the arguments, right? After really looking at it, whether that's a supportable position. But given the importance of the issue, right, we need to look at the possibility that that's available as hard as we can, given the importance of the issue to the economy, the legislative and popular statements in favor of the California policies and so forth. And then I think I couldn't certainly commit to an answer to that question, but for me it would be very important to figure out why this situation is not a blanket authorization to assist in federal crimes, even when state law permits them.
I mean, I guess I wonder, like, what is the status of, say, I don't know if there are any more states. There were states not long ago that had, like, prohibitions on gay marriage.
Pardon?
Prohibitions. There were states that had prohibitions on gay marriage.
Right.
I don't know if that was, I don't know if any of those exist anymore or if they're all constitutionally infirm. And also I'm trying to imagine a law like you've suggested that I would consider backwards state law. I wouldn't want to see a lawyer assisting in, and which is illegal under federal law.
Well, I think the Jim Crow, like, that is a good example.
Sure. But okay, but those laws, the Jim Crow laws, are illegal under what? Well, the Constitution.
Well, I was jumping, and I was thinking about some of the cases which I read long ago in first-year criminal law about intentional deprivations of civil rights, right? Which involved, we treated them as criminal conduct, right? And so that would be the sort of situation you have a state official, perhaps, who you're counseling, right? Who wants to institute a policy which would constitute an intentional violation of the civil rights of.
It's legal under state law.
Yeah.
Well, what's the state law that says it's legal?
What?
What does the state law say? The state law says.
The races shall be separated, whatever. So,
Yeah, some range of things like that. I haven't worked the hypothetical out fully. I just want to think about how we don't endorse a sort of narrow, simple-minded states' rights view that doesn't give any weight to the moral seriousness of a violation of federal criminal law and the weight that it has in a federalist system where the supremacy clause applies.
Right, and I think I get that, but I also, it seems to me, and I think that you're thinking this too because of what you said about what you want, is that it's incomprehensible to me that we can have a serious segment of business and economy and a serious industry that now exists in California just be completely advised by lawyers like that, or so that's the struggle, right?
Yeah, absolutely, and I think that so it may well be as we work our way through that those turn out to be the important distinguishing factors, right? The fact that this is there's been so many broad and open state legislative declarations in favor, that there is so much economic activity associated with, that there are 9 other states where there are similar kinds of commitments in industries, right? The importance to California of being able to vindicate those the uniqueness of the situation, right? Those are the kinds of things that seem to me we need to think hard about as ways of not having this opinion sweep too broadly.
And there is some of that in some of the opinions. I mean, not probably at the level of detail that you're talking about, but I'm
thinking LA, for example, if I remember correctly, I believe that opinion, there are some of these, for lack of a better word, sort of policy consideration. How could you have an industry like this, and what would it mean to have people who could not get any legal advice?
I think that's a great argument, and I think the way Amy put it is extremely powerful as a way of coming back, right, and potentially sustaining the position reached in LA and San Francisco.
I think that there might be something to the interpretation of advising the violation of any law, and to really focus in on what does that mean, and does, drafting a contract, operating agreement, is that really advising the violation of the law? And so if we look at what it is that the lawyer is doing, is that really advising the violation of the law? I think that also might be a potential basis, because when you start talking about the policy of the importance of the economic impact and all of that, and that there's a bunch of states that have permitted this, if you harken back to a different time, those are the kinds of arguments that were being made to support other very terrible things in the history of this country. And so you wouldn't want the southern states to get together and say, it's very, very powerful economically for us to have slaves and whatever, because that's the same kind of argument that could have been made back then to try to resist what was happening at the federal level. And granted, I'm a little embarrassed this being televised, because I don't want people to think that, but I'm just saying that when you start to get into too temporal of a discussion about what's happening now and why that's what, maybe this is one situation where we should be able to advise violation of law. I would just be careful.
I absolutely think that's right. I think it's very important to the integrity of these opinions that you stress that the lawyer has to be completely upfront, right, about the illegality of the conduct under federal law.
Right.
They have to be completely direct, and they have to say what the penalties are.
But I think
and that's not just window dressing. That's actually part of why we would permit the advice with respect to state law.
But I think, correct me if I'm wrong, but I think, and I agree with that. And that also is something that some of the opinions I've picked up on to some degree too. But I think I understand. I think what you were saying, it sounded like, was there's kind of a predicate issue that we're jumping over, which is what actually constitutes advising the violation of law. We're kind of assuming, it's a violation of federal law. You've advised the violation. Now we've got to figure out why is this unique in their policy. I think if I understood what you were saying is we have to look at the rule and what it means to advise the violation of the law and see whether are there limits on that? Some things are advising, some are not. I don't know what the answer is, but we got to look at that. And then wherever that leaves us, if there's conduct that is advising, then is it nonetheless permissible for, because it's unique or these other, is that what you were saying?
It is, exactly, because, if you form somebody's company and you say, look, I'll form your company, I advise you not to sell the stuff, because that's illegal, but I'm here forming your company. Is that really advising the violation of the law? Couldn't you form the company and you're not really advising?
Well, that's where the assisting piece comes in. I think you get a long way with the argument that if you say it's illegal and you don't affirmatively encourage it, right, that you aren't advising the violation of the law. But once you start to draft contract documents, right, or that stuff, that's hornbook assistance.
Well, right, again, just to remember, we don't have assistance in California.
We may not have it in the text, but I'm sure we have it in a lot of decided cases and comments.
Of assistance, as you
I
pointed
agree.
out.
I find all of that, if you're helping someone set up a business to sell marijuana, I think to some degree, you are advising. I don't know. At the same time, you're saying, by the way, this is illegal.
federal law.
So,
Whether you're doing it with intent to violate federal law?
Says
If we,
anything
well,
about
if we adopted, if we agree with the
Intent is doing the act, right?
Yeah.
Yeah, well, if that's all it is,
I mean,
yeah.
the question is how broad is it, what is advising encompass, right? I mean, some people would argue, and some of these opinions have kind of had this, that it's like, well, if there's a state body of law that permits this, and I'm telling you how to act and conduct yourself in compliance with this law, and I tell you there's another body of law out there which this may violate, but you're here in California, you're trying to do this, you're trying to do this under California's rubric. My advice to you, I'm not advising you to go out and violate the federal law. I'm advising you how to comply with the California law. There's a collateral effect of you doing anything that in compliance with the California law because of the fact that the federal law is at odds with it. But, I mean, some people would say, that's not advising. Advising has got to be like, I want you to go out and break the federal law, and I'm telling you to do that and encouraging you to do that. Which, if the state law wasn't in place, would clearly be the case. The question is, does the state law rubric being in place change that? You've raised, I think, a very legitimate issue, which is, how do we get away from just saying, well, if you have some terrible state law, that how is this not just a carte blanche to go, basically violate federal law or help people violate federal law as long as there's a state law, good, bad, or whatever, that says that you can do this. But I do think the issue of what is the scope under the rule in terms of how advising has been defined, we're going to have to look at that. There's no question. Because some people are saying that. Some people say, it's almost like an intent thing. Like Richard, some people say, it's not advising the violation of the law if there's a body of law that allows it, and I'm not doing this because I want you to be violating federal law. I'm doing it because I want to help you stay in compliance with California law, and there is a collateral effect under this other federal scheme.
I don't know how well, I'm not sure how well that works.
So I'm not saying
No, I think it's an interesting line to think about.
But it's definitely out there.
Yeah.
And I don't know the answer from a research standpoint of under 3-210, how is it by this concept of advising? And I think that's your point, right? We got to tackle that in addition to the.
I think we have to tackle that and what is a violation of the law? Because I'm not a criminal lawyer, but I don't know. I mean, it seems to me selling, like the act of selling an illegal substance is illegal. Is the act of forming a company illegal under any law? Probably not. Right? So we're going to have to look as well at what is the illegal piece of the conduct that we might be advising. I mean, I don't think the formation of a company is illegal.
I don't know, unless there's some aiding and abetting type of the nature of the business is illegal under federal law, therefore you helping them put it together.
Right,
I don't think there's any question that helping some mafia don incorporate a business to launder money for drugs.
Right, but
with knowledge that that's what it was
with
doing.
Knowledge, right. I mean, with
yeah,
knowledge.
but knowledge is the key.
I guess you have
Right. So,
Yeah, sorry, I know we're running out of time. I just want to make a couple points that I don't necessarily know the answer to, but I know that these issues have come up in the wake of the LA opinion and the San Francisco opinion in that, okay, great, you tell me I can give this advice, but that doesn't help me as one of these lawyers that is doing this because there are other pieces to the puzzle. For instance, if we're telling them whether they can ethically advise, there are certain attorney-client privilege implications that are at issue. If you accept more than $10,000 and you deposit it into your bank, you could be money laundering under the federal law. And as an attorney, you're required to keep certain funds in a trust account. I mean, there are other ethical things that come into play. So it's like, are you going to give this advice for free and not worry about your other ethical obligations as far as accepting money from clients and keeping it in your trust account. And then if they get in trouble under the federal law, a lot of the attorney-client privilege that we rely on here in California wouldn't necessarily apply. So when you're advising them of the difference between state law and federal law, do you also have to advise them, oh yeah, and if for some reason you get in trouble under federal law, everything we've talked about might no longer be privileged. And you also aren't necessarily going to have the, I relied on the advice of my counsel defense. So there's those issues too, which when you first started talking about this, I thought, well, that would be great, because if we go a little further and talk about all the ethical issues that might be at issue here, then I think that would be more helpful to these attorneys that actually do practice this law.
Oh, I think without question, I mean, the issue of can you advise them about the law, that,
Right.
I think I said, that's the easy part.
Right.
And
Right.
that most of the, I mean, and I'm not saying we've reached a conclusion, but I mean, there's a lot of, it's easier to get to the conclusion that telling someone about the law and what it is,
Right.
and how their conduct would or wouldn't comply with the law is not advising the violation of the law, even if that conduct would violate federal law. That's kind of the easy. The hard part is when you get, or potentially harder part is when you get beyond that into, more than just telling them what the law is, But now you're doing something. You're with them in a motivation or a course of action or accomplishing some kind of end. You're trying to do something, whether it's the contract, whether it's telling them how to arrange things to comply with. I mean, so
Yeah.
I don't think any long-winded way of saying I think that the opinion hopefully would go beyond just that sort of predicate question, because I think you're right.
Yeah, and once you go past that basic step, which these other opinions have already gone to, it opens up a whole slew of issues that haven't really been considered, which I think would be fantastic if we took that on. But it's something that I think will be a big undertaking for sure.
Do you have how do you know these issues, and it'd be great to sort of get a list.
So there were some attorneys in my firm that dealt with some of these issues and would ask different counsel what our opinions are. But I've also read a lot about it, specifically attorneys in California that have almost complained about these other ethics opinions and say, great, thanks for telling me that I can advise them about the law, but I'm having trouble doing that because in my attorney-client relationship, there are these other ethical issues that are coming up that I don't know what to do.
Well, isn't it really that they want to go beyond, that most clients really don't want just sort of this concept of advice in a vacuum,
Right.
like what is the law?
Right.
That's not the end of the story normally.
Right, but
The
even
scope of what they need
effectuating a relationship, like, for instance, the payment of fees. I mean, that's just one example. Do you deposit that money that you know is coming from someone that's running a marijuana business, which, yes, is legal in California, but you're then putting it in a bank that's federally regulated. And then, you have obligations under our ethics rules with trust accounts and everything else. And you're required to report anything that you deposit over $10,000. And if it comes from a known marijuana facility under federal law, that's money laundering. I mean,
For the client or
for the attorney.
Okay, so is that an ethical issue as it runs
Well,
to the
I
client?
think-
That's an attorney liability issue.
Right, and I think some of this kind of toes the line between both. So, and then the attorney-client privilege issue is something that's a real issue. Now, you look at the Cole memorandum and other things that talk about how, we're not going to pursue these things, but it doesn't necessarily say that they will never do it. So I think when you're advising, like these other opinions have said, you have to advise that this is illegal under the federal law. I think a part of that, if we say that in this opinion, is, and by the way, if you do get in trouble under federal law, our communications may no longer be confidential.
No, I mean, I agree that the privilege has got an ethical issue. The Cole memo is out the window now.
Right.
Because Sessions said, or not out the window, but there's been an indication that they're not going to abide by that any longer. that was,
It's been rescinded.
well, okay, it's been formally rescinded.
January 4th.
Okay, so it is out the window.
Okay,
But-
I didn't know if that was official or not.
Yeah, but I mean, that's something that's also been thrown out in these opinions when they try to cobble together, sort of, for lack of a better, why is this different, or what makes this unusual, and one of the
Insurance
things.
coverage, that's another one, which I know is not a requirement.
What?
Insurance
Oh,
coverage.
yeah, right.
But there are a lot of these issues of how, okay, you can do it, but how do you practically do it? And like I said, I do not personally do this. These are just issues I've heard, so it's something that I would have to look into further. And you're right, we don't want to go over ethics. We want to stick with the ethics
Right.
stuff. But there's a lot of
No, I'm sure.
things that
And
this treads on.
at the end of the day, it has to be something that goes beyond just the very preliminary question of, can I advise someone about the law, which I think is the easier part. But it's also not gonna run down every, there's gotta be a zillion of those things you're talking about.
Right.
But it would be good to know what they are, and some, to the extent some of them are key troublesome areas, and they are on that ethics line side of the equation.
There
and-
have been a lot of articles and things written about it, so I could probably gather some of those up, which will at least give us some preliminary bullet
That'd be
points to
great.
look into.
That'd be great.
But whether that's exhaustive, I don't know.
I was wondering, I have a former student at a firm in Oakland that advertises that it gives cannabis advice, which I thought was interesting. They're a pretty big firm, not a huge firm, but a pretty big one. And I was thinking, I was thinking I might call him and ask him what kinds of issues they face and how they,
That'd be great.
So.
Okay, well,
That's super interesting.
we're running out of time, but that's helpful. And we have yet to have had this type of discussion on this opinion. It seems to me that on the very initial question about, there's a comment pending and all of that, I hear strong support in moving forward with the opinion regardless of what happens regarding, pending rules and comments.
It's easier with a comment, right?
Well, yeah, that'll help us if that happens, but so I think we move forward, and I think we got some good ideas about things to look at, so thanks. All right, we'll adjourn then. Thank you all for coming.
Yes, that's, do it.
Although I don't feel like there was a lot of practical
Yeah, well,
guidance.
there will be some detail.
Maybe some more brainstorming conversations.
Sure, yeah, I think that's a great idea to
Yeah, we'll do some bunch of things.
about that one.
That's 10.
Get some.